Good afternoon, Justice Kern. How are you?
Good, how are you?
I'm good. I can see you. I can hear you. Okay, it's now 1:59, so quarter start in approximately 1 minute, right? Have a good afternoon to both of you.
You too. Nice to see you with your mask off.
Please rise. The Justice of the Appellate Division Supreme Court, First Department. He, all persons having business with the Appellate Division Court here, giving attendance shall be heard. Okay, thank you. Please be seated. Hey, good afternoon, everyone. If you noticed here, it's obviously it's not it's a visual effect. We have two justices on camera today. The justice presiding is Justice Kern, and we have Justice Scarpula also on video today. I am by I guess seniority status in the middle, and we'll be running the clock. So we have over 6 hours of argument time requested for today. We have read your briefs. We know your issues, so please limit your argument time to what you think we need to hear. Again, the clock is for you and not for us. Thank you. So, People versus Michael Longo. Okay, I will give 5 and 3 and 4. Kostyatnikov versus HFZ Capital Group.
Appellant, request 7 and 2, Your Honor. Respond, request 5, Your Honor.
I will give 5 and 3 and 4. Thank you. E. Johnny versus Bobby C. That's submitted. AM versus City of New York. I will give 5, 3, and 4. Thank you. Advanced Magazine Publishers versus Corporate Suites.
Request 5 minutes.
There's no respondent. You wish to submit?
Stand by. Your Honor, I'll take the podium in the event of.
All right. Well, anybody have any questions on this case? No. Justice Higgett? No. We're good. Submit. We have no questions. Submit then. Thank you. People versus Guzman. Okay, submitted. Carter versus Sweeney. I'm sorry? 10 minutes? All right. You don't want any rebuttal time? 10 and 2. All right. So I'll give you 7 and 3 and 5. Thank you. We have Vavalva versus A.O. Smith.
No, Your Honor, we have 5.
I'm sorry?
Respondent request 4, please.
5 and, Counsel, you said 5 and 2?
Respondent 4 minutes, Your
No,
Honor.
I got
5 and 3 if we may, Your Honor.
5 and 3 and 4. Thank you. Levinson versus 77 Perry.
Appellant request 7 and 3, Your Honor. Respondent request 7, Your Honor.
5 and 3 and 4. Thank you. People versus David Garcia. 3 and 1 and 3, thank you. Gloria B versus Rachel BT. As submitted. Suarez versus AIDS.
5 and 2, Your Honor. Respondent request 5 and 2 as well.
5 and 2, 5 and 2, thank you. People versus Lady P. That's submitted. Sahival versus Industrial Staffing. Any respondent? I'll give you 5 minutes, ma'am. Thank you. Extended CHHA versus Mahoney.
Your Honor, appellant request 12 and 2. Respondent request 5.
I'll give you 8 and 3 and 6. Thank you. People versus Anthony Esquilin. It's submitted. Celentano versus City of New York. There's no other appellant? Okay. I'll give you 4 and 3 and 5. People versus Michael Ross. Did you say 6 and 2? 6 and 2, and I'm sorry? 6, okay, 6, 2, and 5, thank you. And the last one is Eagle Eye Collection versus Otery. That is submitted. Thank you. Okay, first case on the calendar, People versus Longo.
Good afternoon, Your Honors.
Thank you.
Stephen Strother from the Office of the Appellate Defender on behalf of Michael Longo. 4 times during summation in this case, the prosecutor told the jury that this DNA evidence is conclusive proof beyond a reasonable doubt that Mr. Longo was driving the car at the precise time of the accident. No DNA evidence could support that argument, especially not the DNA evidence here. The DNA evidence here is YSTR testing. The Court of Appeals has explained, as well as the expert in this case, that all that testing can do, because all it tests is male chromosomes, is show.
But counsel, was this all drawn out before the jury and on the cross-examination? All these issues that you're raising right now in front of us were presented to the jury?
So not
No? Yes or no?
Some of it. Defense counsel brought
Some
out
of
a few
it,
of these
not
facts.
all of it, not enough?
Certainly not enough, no. And also, regardless of whether they're drawn out before the jury, in right they were as well. The defense counsel in that case asked a lot of questions about the weaknesses of the DNA evidence, but the prosecutor making an argument that is completely unwarranted by that evidence is still prosecutorial misconduct.
Counsel, was
regardless.
there any summation by defense counsel that would warrant the prosecution's response? The defense counsel saying that there was not even a match, warranting that the prosecutor respond to that?
So the defense counsel definitely argued that the DNA evidence, that the pool of people it could match to was very large. But even if defense counsel made that argument, the prosecutor's not allowed to respond with an argument that is not actually warranted by the evidence. You can't state something the evidence doesn't support just because defense counsel attacks the DNA in summation. The problem here is that the DNA evidence can only show that a person is not excluded from a pool. Here, that pool is thousands of New Yorkers, and no DNA evidence can ever show that when a sample was left on a surface, The only contested issue in this case is who was driving the car at the moment of that accident.
Okay, so let's speak about that. Was there other evidence in this case, a video, other evidence of testimony? And then in addition to that, DNA evidence, but the other evidence, was it so overwhelming that this DNA, if there was in fact an error, was it harmless?
No, because a few reasons. One is that this is a circumstantial evidence case, and there's no testimony that Mr. Longo or any evidence that he was driving it at the accident time or afterwards. And in Wright, the Court of Appeals says that DNA evidence...
There wasn't video of him driving the vehicle?
Before the accident, not during or after. There's no direct evidence at the time of the accident or after. And the Court of Appeals in Wright makes clear that improperly bolstered DNA evidence is uniquely harmful, that there is almost no way to cure the harm of something like that because the jury is likely, due to the patina of an expert giving testimony and to the authority of the prosecutor, to draw the inference that that evidence is conclusive. The prosecution knew that in this case. That's why they said to the jury, this is conclusive evidence of proof, even though no DNA testing can ever show that DNA taken from somewhere was deposited at a specific time. And that was the only fact that mattered here. He turned the DNA into the direct evidence they didn't have. That is the kind of error that must be reversed, and this court can't
Well,
hold...
counsel, I'm glad you mentioned that, because in that case, was there an objection lodged then at that point by defense counsel to the court?
No, and that's why it's ineffective assistance of counsel. Wright addressed this without a 440 on the record, identical facts.
Well, I don't have the 440 in front of me, right?
Say that?
You said it's a 440 application?
No, I said that Wright reversed without a 440 in identical circumstances. If this court doesn't do that, it's effectively shadow overruling the Court of Appeals. It's exactly the same case.
Well, we wouldn't want to do that.
I agree.
Right.
And so, if this court and Your Honor asked the question about harmless error, if this court was to hold it was harmless, that would be saying, well, as long as you have some other evidence, you're allowed to have a little prosecutorial misconduct at the end. And that's not the law. This is a violation of due process, and it's also about an officer of the court knowingly misrepresenting evidence. That expert's testimony never once said, when you pick up DNA, that tells you exactly when it was placed there. The prosecution knew that was the only contested fact, and he got up in front of the jury and said, this is conclusive proof beyond a reasonable doubt that he was driving it at that moment. No DNA evidence can ever show that. It's bedrock, basic principle of DNA testing. If he goes that far beyond what DNA testing could show, certainly the prosecutor didn't think he had an open and shut case, and we agreed to call it harmless when he needs to overstate evidence.
You have rebuttal time.
Thank you.
May it please the court, Matthew White for the people. May I take my mask off, Your Honor, while arguing?
I don't know if that's the rules.
The rules are this week.
I think you're allowed to take your mask off when you're arguing, yeah.
Okay, thank you. I'm a low talker. No one can ever hear
You
me.
may want to hold the mic a little further down below, yeah.
Sure.
Well, before you start, let me just ask you, can you just address your adversary's analysis of the Wright case as it pertains to these facts?
Absolutely. Wright and this case are the same insofar as they involve the same type of DNA testing. Otherwise, Wright is completely different. In Wright, the prosecutor said that the defendant left his DNA all over the crime scene and used the DNA as the sole evidence of guilt. In Wright, the criminalist testified, however, that there were multiple contributors to the victim, and the best that could be said was that the defendant was not excluded. Here, by contrast, there was one contributor to the DNA that was recovered on the steering wheel, and it was the same YSTR profile that defendant had. And that was the criminalist's exact testimony, that it was the same as the defendant's YSTR profile and that it was a match. Another difference with Wright is that the prosecutor relied heavily on the DNA in that case to prove the guilt. Here, the prosecutor did not. The prosecutor didn't even mention the DNA in his opening statement. That's how little the prosecutor was relying on this evidence, and it took up approximately 5% of his summation. Another significant difference with Wright is that there was no statistical analysis in that case regarding this, the DNA evidence. Here, a statistical evidence was done, and as Your Honor pointed out, everything was before the jury what the significance of a YSTR DNA match meant.
Is your friend correct that the trial assistant referred to this DNA evidence in summation as conclusive?
No, that is incorrect. The prosecutor repeatedly stated that there was only one source of DNA that was recovered from the steering wheel, and that tended to disprove defendant's claim that he had somehow loaned his car out for 20 minutes to someone else. And you know, that was how it was used, just to show that there was one contributor to the DNA on the steering wheel. The claim is unpreserved, defense never objected, and there's no reason to reach it in the interest of justice because defendant ran over someone and left him to die. The evidence of guilt was also overwhelming. He's on video driving 10 minutes before the crash. He's seen walking home 10 minutes after the crash from where his damaged car was parked 3 blocks from his house. There's eyewitness testimony that it was his car and that he had had a fight with his girlfriend minutes before the crash, before he threw her out and drove off angrily. Paint chips from the car were found on the decedent's clothes. Receipts with the defendant's name were found in the car. There's the video of the crash itself. There was an eyewitness to the crash who, even though he couldn't identify the driver, said it was a white male like the defendant. And against all this evidence was the defense that maybe defendant loaned his car to some unknown person for 20 minutes and took the bus home. And the DNA tended to disprove that because it showed that there was not a mix of DNA found on the steering wheel. There was only one contributor, that was defendant. And that was how the DNA evidence was used. And unless your honors have any questions, I ask that you affirm and rely on my brief.
Thank you.
So a couple of quick points here, especially about the Wright case. So these distinctions that he's talking about are distinctions without a difference, because the important thing here is that there could be factual differences between, details of the DNA evidence in the case, but the misconduct is the same. The misconduct is still overstating what YSTR testing could show. The expert here did use the word same. However, as we point out in our briefs, saying the prosecutor's allowed to use that term would just be to say the expert is also allowed to say something false, because he also says otherwise in his testimony that YSTR testing cannot provide a match. It's impossible for it to do so.
Well, presumably if the Court of Appeals heard the case, there must have been a preserved error of law for their review.
No, actually, in Wright, it was a claim of ineffective assistance of counsel for failure to object, and they also found that it was ineffective assistance because it was prosecutorial misconduct to make this argument. So,
what is the standard though before us to reverse for prosecutorial misconduct during the course of summation where the claims are unpreserved?
Well, you have to reach the interest of justice, but at that point, the standard is the same, which is that it renders the trial unfair. Which in this case it certainly does, because he's looking straight at the jurors and saying to them, and just to correct defense counsel here, the prosecutor looked at them, and I want to quote from his summation. He says that the DNA evidence provides overwhelming evidence of Mr. Longo's identity at the time that he was driving the car. And he says that, it'd be pretty hard to really say, to say it's conclusive any more clearly than that. And again, it's not supported. Now,
did he say that more than once?
The word overwhelming evidence? Mm-hmm. It was the last thing he said to the jury. It was, yes. The other point is that counsel keeps saying he uses it to rebut the defense, as if that makes it okay, but that's precisely why it's a problem. If the DNA couldn't rebut the defense as it couldn't, then the prosecutor was supposed to say that. What if he walked to the jury and said the truth? We have a DNA sample. We can't say for sure that it's Mr. Longo's because it could also belong to one of thousands of other people. And also, it could have been put there a couple of weeks ago. What's a jury going to think? Well, that DNA evidence doesn't mean anything. But why? Because it doesn't. It has no probative value. Sure, the prosecutor wanted it to rebut the defense. The problem is that it couldn't. He wasn't allowed to get up there and say it does. That's a false statement. Prosecutors can't argue false statements to the jury. That's bedrock constitutional law. And so for that reason, the court has to reverse. Otherwise, it's telling prosecutors, this is fine, go ahead and do it. And this is the most powerful evidence in our system. The Court of Appeals has been very clear about that.
Thank you, counsel. Kostinavkov versus HFZ Capital. Okay, you're up.
Good afternoon. May it please the court. Gary Menn of Deckert LLP for Appellant CIM Astor Owner. There's no dispute about the operative facts here. A parent corporation, defendant in this action but not involved in the appeal, defaulted on an obligation to deliver an apartment on Madison Avenue to the plaintiff appellee. Years after that default.
I mean, I think the issue here is whether or not you can pierce the corporate veil. Am I correct? I mean, that's I think that's one of the main points here, right?
That is the determinative issue, Your Honor.
Why don't you just focus on that and why you think Supreme Court erred in not dismissing the case based on that?
Your Honor, first, the trial court failed to address the proximate cause issue, which requires the respondent to plead acts by appellant that proximately cause the plaintiff's.
Is that required when you're asserting a piercing a corporate veil theory that you need to do proximate cause? I didn't think that. I thought that some of the four factors that sort of embedded in my head, I never remembered, but correct me if I'm wrong, there may be a development out there that I don't know of that requires proximate cause in that analysis.
Yes, Your Honor. Proximate cause is required for any claim, and the
No. The theory of piercing the corporate veil. I agree with the claim, but piercing the corporate veil, what are the factors to allege to allow you to go forward on that theory? Maybe I'm not saying it right, or am I getting something wrong here?
Well, Your Honor, to pierce the veil and hold the individual defendants liable for the corporation's actions, plaintiffs are required to allege, first, that a complete domination with respect to the transaction attached, and that such domination was used to commit a fraud or wrong against the plaintiff, resulting in plaintiff's injury. That is the proximate cause requirement. That's this court's Cahan Jewelry decision, 2019. What's required is that the misuse of the corporate form.
Yeah, but we're at the pleading stage. We're not at summary judgment, right? So that might be where I might disagree with you. While you may have to have proximate cause, but that's down the road when you move for summary judgment. Unless I'm mistaken, we're at a pleading stage, right?
We are at the pleading stage, Your Honor, but in this case, what is pled in the complaint, the chronology that is pled is inconsistent with any allegation of proximate cause. And let me just run through that chronology. So in 2011, they invested $3.8 million.
Well, let me just ask this question. In terms of the ownership, the officers, the common space, the telephone numbers, Mr. Feldman, all of these overlapping things, does that in any way establish the elements of the alter ego liability, which we can agree doesn't need to be pled specifically, but
Your Honor, I agree. They've adequately alleged control. They've adequately alleged control. All of these entities were controlled by the same group of people. But what they don't adequately allege is that the involvement of this particular entity. Basically what happened is you have an innocent affiliate. The parent owes money to someone else. The parent promises that person that they will acquire something from the innocent affiliate, an apartment, and give it to this other person who's the plaintiff to satisfy the plaintiff's claim. But it has the only involvement of the innocent affiliate, which is the appellant. There's no allegation that they did anything wrong whatsoever anywhere in the complaint. The only allegation is that they refused then to turn over their asset without compensation. They did not sign the agreement. They're not even referenced by name in the agreement.
right. But at the pleading stage, as my colleague indicated, why isn't it enough to just allege that these parties are interchangeable and they acted as such, and here we are? And then maybe that's your argument for summary judgment
Well,
or at trial?
you know, I think, I can understand that position with respect to the control element, but with respect to the second element laid out in Kahan, that the domination is used to commit a fraud or wrong against the plaintiff, that is not alleged here. There's just no allegation whatsoever that could be read to mean that, let alone that it resulted in their injury. Because again, if you look at the chronology, they don't allege anything with respect to the appellant until after they've already lost their $3.8 million. Basically, the allegation is they lose the $3.8 million with respect to these other entities, and then they tell the control people, tell the plaintiff, we're going to try to acquire this apartment from the appellant, and then they never acquire from the appellant because the appellant is a pledged asset itself and is unable to make that transfer without getting compensated.
Okay, thank you.
Thank you.
May it please the court, Joseph Pakin, Krieg and Adams, for respondents, Sergei Kostyatnikov and VSK East 68th LLC. So when counsel is speaking about timing of everything, that they'd already lost the money, it's just not true. In 2016, my clients were supposed to get an apartment 7A in a building on East 68th Street.
So let's get to the heart of it. He's saying that there's no, we have a reverse piercing of the corporate rail, where you're trying to get from the parent to the affiliate. And he says that that's not, the Supreme Court erred in allowing that to go forward. What's your response to that? He's saying that there's no proximate cause, it's really apples and oranges. That's the end of it.
I think the Supreme Court got it right. I mean, this was clearly, everything was controlled by the same two people. You've got charts of control put in by defendants in their motion to dismiss, not this defendant, but the other defendants. And they show that Feldman controlled HFC Capital through 9 different entities controlled the 2 buildings, the 68th Street building and the 75th Street building. And they represented my client. There's an affidavit where it says, you know, we were told that we can't buy the 7A because there's some kind of problems with it, but the 7A was still there. That's the first apartment. So that was there in 2016. So they negotiate and they sign this agreement to switch the other building because Feldman and Mir, the control people, are telling them 7A is going to take forever to get, so go to one of our other buildings. They control all these buildings. So to say that his client, which was an innocent party, is just not true. They're all one and the same. They used the $3.8 million of my client probably to show their balance sheet to get funding for the 75th Street building. And the timing, my client hadn't lost its money at that point in time. It could have taken the 7A. It just would have taken longer. It was there. It wasn't sold till 2018, and I think it's on, we have the deed next to the record as well, and it shows when it was sold. I think it's page 304 of the record where the affidavit will reference it. So in sum, my client hadn't lost his money at that point in time, and they got snookered into moving over to 75th so that Feldman and his related HFC entities could keep the $3.8 million, and ultimately they were insolvent.
Okay. Any questions? Do you have anything else you want to add? No?
That's it,
Okay,
Your Honors.
thank you.
Thank you.
Your Honor, if as my adversary had just said, there was an allegation in the complaint that the $3.8 million that they invested was used for the Astor, then obviously this would be a totally different case. They don't allege that because it didn't happen. It's not in the complaint. It's not in their brief. I've never heard that before just now. It's not true. The $3.8 million.
Did they plead proximate cause in the complaint, even in the most conclusory of fashions?
They do not, and they cannot, given the chronology that I've laid out. in the complaint, it is clear that the first time that my client appears in the complaint is in 2016, years after they've made this investment and their money is gone. And that's clear in the complaint. So no, there's absolutely nothing in the complaint that suggests that anything my client did or the misuse of my client's corporate form caused their loss in any way. And I wanted to cite, we have it in our brief, but I do think the case is very important. Gateway International versus Richmond Capital, which is January of this year, this court. And in that case, you had a genuine fraud by a man named Braun who passed himself off as someone else named Jack Snyder. So he was using an alias and committed a fraud, and he had 3 corporations. And of course, there was a fraud claim against him, but the court dismissed, on a 3211 motion, this court dismissed the piercing the veil claim because that was not, the fraud was that he was passing himself as somebody else. It wasn't the misuse of the corporate forms, the entities that he had loaned money and got repaid. Unless the court has any other questions?
Okay, thank you.
Thank you, Your Honor.
AM versus New York City Department of Education. Thank you.
Good afternoon, Your Honors. May it please the Court, Jonathan Popolo for Appellant, Department of Education. There are 2 independent reasons why summary judgment should have been granted and erroneously was not. The first is that the supervision provided by the Department of Education met the reasonably prudent parent standard as a matter of law. And the second is that even assuming an issue of fact as to the level, as the adequacy of the supervision, no reasonable level of supervision could have prevented the sudden spontaneous accident. So there's no.
Well, counsel, let's take the first issue in terms of who was supervising or where the supervision was. There was a paraprofessional in that particular area, but her purpose was not to supervise the students. She was specific for one individual special needs student, right? So the other students were unattended.
That's not accurate, Your Honor. I mean, the first part of it is correct, and that was her sort of charge. She was assigned to a particular student, not just at recess, but she was assigned to a specific special needs student. But she clearly testified that at recess, she was charged with watching over everybody, and that she did do that on the day in question. And I think if you look in the record at page 311, there's a photograph of the very small area where the jungle gym playground apparatus is located, and it's a very small, contained area. So it's entirely possible for her to stand there and watch her student, her special education student that she was assigned to, and also all the other children who were in that particular area at the time. And she plainly testified that she had been verbally instructed by other school officials that, her responsibility during lunch and recess was to watch over, everybody, not just everybody sort of within her purview where she was located, not just her particular student. And the testimony is unequivocal, her deposition testimony was unequivocal that on the day in question, she was watching over everybody.
Okay, so then,
So,
sorry, go ahead.
I mean, yes, but she also testified when asked directly, were you supposed to supervise the other students? She said, not particularly, and I'm quoting specifically. Her own testimony creates an issue of fact as to whether or not she really was supposed to. At one point in her testimony, she says yes, and another, she says no. And I read the same deposition that you did.
I know, Your Honor, and I think the not particularly question was a question about, like, do you view it as your responsibility? Is it one of your responsibilities? They're asking a sort of general question.
Well, I mean, come on. So that is basically inconsistent, that testimony, with her supervising the other kids.
The follow-up question after that, though, is it fair to say then that at a recess, if there's two children who aren't, one of them's not your child and the other one's not someone who's interacting in, is it fair to say that you're not watching over them? And she said, no, that's not fair to say. When I'm at lunch, when I'm at recess, I have an obligation to watch over everybody. I mean, so I don't think there's actually a contradiction there. There's a follow-up where she makes clear that she is watching over all the children in that area.
I mean, right, but can she see them? Another way of viewing that is to say, someone says to her, can you see all the other kids? Sure, I can see them. It's a small area. But when she's asked, is it your job to supervise them? And she says, not particularly, that creates an issue of fact. Don't you agree?
I don't, Your Honor, especially for the reasons I just said, and also for the fact that
Okay.
for whatever it was,
Fair
her
enough.
testimony about what she actually did during that research shows that during that recess shows that she was supervised.
Okay, say I agree with you. Let's just say that she's watching all the kids in the fenced-in area, because that was her area that she's watching, correct? That's her testimony, that I was responsible for the kids, for the children in the fenced-in area. What concerns me, which I was interested in, where is the deposition of Christine Aguilar, the teacher's aide? Because that would be helpful to me to see what she was doing outside of the fenced-in area. Why don't we have her deposition?
I think you'd have to direct that question to.
I don't have to direct the question. I'm just asking. It's not in the record.
Okay,
So that's problematic because it all comes down to supervision, correct? I mean, the issue is here. You're arguing that no amount of supervision would have been able to avoid the spontaneous incident here, or the spontaneous hit that the kids ended up doing. But I like to, in my mind, to get a complete picture, is like I like to hear what the other teacher's aide's position is, because the child was running into the fenced-in area from the outside part of the playground.
Right.
Just to get a full picture. I only got one picture of what happened, right?
I understand that, Your Honor. I'm just saying I don't think you can hold that against the Department of Education.
I'm not holding it.
here
I'm just
because-
saying that there's still, to my mind, there's a fact.
I don't think the absence of that creates a material issue of fact, especially when
fair
plaintiff
enough.
has the obligation to make their case.
Thank you. All right, you have rebuttal time. Thank you.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. It is undisputed on this record by Ms. Yee's testimony that she is responsible for her IEP student. In fact, at 405, like Judge Scarpullo pointed out, she said that she's not particularly responsible for watching other students. And to the extent it's inconsistent with her saying that she's responsible, that she watches everybody in the playground, that inures to my benefit as the party opposing summary judgment. But I think is actually really important. If you look at 406 of the record, I think what my adversary is relying on, which is, I think, hurtful to him, is her testimony that I watch everyone in the spot that I am. Now let's look at the spot. If you look at 310 of the record, the plaintiff wasn't in her spot. She testified, Ms. Yee testified that she was standing next to the slide. At 310 of the record, you see the picture, close-up picture of the interior playground. She's standing next to the slide. AM testifies that where he was injured, is on the other side of the playground, and it's not visible in the photograph. So I'm not so sure that she can't watch, he's not in her spot.
Well, counsel, let's move on from that, and let's talk about the foreseeability issue, right?
Sure.
Does your adversary, he was starting to talk about this, and then we moved on to something else. But in terms of the spontaneous action of the other child running into or jumping onto, the infant plaintiff, how is that liability pushed onto the DOE?
Well, I think it wasn't spontaneous for two reasons. One, Ms. Yee, admittedly, prior to this incident, told a group of students on 2 to 5 occasions to stop running. And she did nothing other than, and they didn't stop running. So that, to me, shows that it was inadequate because she's watching her IEP student. She admittedly watches him go down the slide, but she's telling this other group of students to stop running, and they didn't stop running, which to me shows that there wasn't adequate supervision because she's focused on her IEP student. The other reason why I think that this shows this was inadequate supervision is because the school was it was admittedly, Ms. Yee testified that they knew about that kids were having problems. They were having problems corralling the kids to stop running, and that they actually prepped them before they went out on the playground, which Ms. Yee said wasn't her responsibility, to not run. So they had the knowledge that that they were running on the playground, that what they were doing wasn't working. So there has to be a plan B. There can't just be, you can't just tell a group of students 2 to 5 times to stop running, and then they just keep running, when she's responsible for her IEP student that's on the slide.
Well, you know, the other thing is, I raised this with your with counsel here about, you know, they're moving for summary judgment. I'd like to see what the teacher aide had to say about the whole situation. There was 2 people there in terms of supervising the children. I only have one side of the story. I'd like to hear both sides. I mean, I want to hear what the other side, because this boils down to a supervision issue. Was there enough presence there for supervision? I only have one side of the story. I don't have the other side of the story.
Correct. And to that point, what I think is really problematic here is that Ms. Yee testified she had no idea what Christine was doing on the other playground. She had no idea where she was, what she was doing, and Ms. Yee admitted in her deposition that it's Christine that's responsible for supervising the playground. I'm responsible for my IEP student. Christine's responsible for the playground. I have no idea what she's doing at the time of the incident. With regard to that, it's defendant's burden, and they didn't establish as a matter of law that no amount of supervision could have prevented this incident. If there's no further questions, I'll rest on my brief.
Thank you.
Thank you very much.
Thank you. Thank you, Your Honors. I wanted to pick up on this proximate cause point. First of all, I think it may have gotten lost a little bit, but the area of the playground that Christine was supervising, running was permitted.
Right.
So there wouldn't have been sort of any reason for her to tell someone to stop running in that area. And the version of
well, that's if she's there too, right? I mean, we don't know where we don't know what she was doing, right?
Well, we don't have her firsthand account because plaintiffs.
But yeah, you're moving for summary judgment, right? I mean, am I incorrect in that regard?
We did move for summary judgment, right. But you know, we're not.
I'm just making a point. Right. I'm just noting.
Understood, Your Honor. But I think even putting that aside, on the proximate cause point, if you look at either version of the mechanism of the accident, it was a sudden, spontaneous event that no reasonable amount of supervision could have prevented. And I think that the arguments that counsel made about how it's not spontaneous, you know, aren't at all persuasive and aren't sufficient. I think all that, you know, there's no indication, if you look at the version where that the child gave of the accident, where the other child jumped off the jungle gym or fell off the jungle gym onto him, you know, there's no indication that that's something that had ever happened before that could have been prevented by any increased level of supervision. And I think probably might want to return to first principles a little bit here. The Court of Appeals has made clear that schools are not insurers of safety. They cannot reasonably be expected to continuously supervise and control all movements and activities of students. And that's why
So counsel, can I interrupt you for a second?
Of course, Your
Wasn't
Honor.
there testimony from the infant that the kid was on the whatever he jumped off of for quite a while?
I don't recall that, Your Honor.
I saw some testimony where he said,
Okay.
yeah, the kid was up there for a bit.
For a bit.
Right? So if he's up there for a bit and there's reasonable, the question then is, if that testimony is accepted, don't forget we're doing summary judgment here, there could be approximate cause for failure to supervise, right? If he's up there for 10 minutes and there's nobody there telling him to get down, and then he jumps on the plaintiff, that raises an issue of proximate cause, right?
Right, but paraprofessional.
So we're not talking about insurers. We're talking about different people having different views of what happened that day. That's the problem.
But if I could respond to that, the paraprofessional, Ms. Yee, testified that that students, it's good, students were not allowed to jump off the the apparatus. That was prohibited. But but they were allowed to play on it. So there's nothing here where it shows that this was like she had any sort of notice that he was going to jump off. It wasn't like it wasn't like he was like a repeat offender.
That nobody jumped off of anything, that the two kids ran into each other?
Correct, but I think we're
So
basing
here
it on.
again, you're asking us to accept sort of half of her testimony and not accept half of her testimony?
No, Your Honor, I'm saying that under either description of the mechanism of the accident, there still was not proximate cause. It was still sudden and spontaneous and couldn't have been prevented by any reasonable level of supervision. So the fact that there's a dispute as to the mechanism of the injury is not material here, so it shouldn't defeat summary
You don't
judgment.
think that if the student's testimony that she was up there, the kid was up there for several minutes and no one told him to get down and then he jumped, that doesn't raise an issue of fact as to proximate causation?
No, because he was allowed to play on the jungle gym.
No, but yeah, okay, but no, I thought that you just said that nobody was allowed to stand on those.
It wasn't allowed to jump off it. That's what he testified, that was prohibited, jumping off it.
Okay, thank you. Carter versus Sweeney.
Good afternoon. May it please the court, my name is Jonathan Davis. I appear on behalf of Michael Wayne Carter, Jr., also known as Little Wayne. This appeal seeks to reverse the court below's dismissal of the complaint, except for a portion of the 10th cause of action for declaratory relief. The court also did not even discuss the request for or the motion for leave to amend in the event of any dismissal of the claims. Mr. Carter, for more than 2 decades, has been one of the most celebrated and recognized rap artists in the world. The respondent, Mr. Sweeney, is an entertainment lawyer from California. The facts in this case are really stunning, given that Mr. Carter, for more than 13 years, was practicing in New York City without a law license and a sometimes suspended lawyer from California.
At the time that Mr. Carter engaged the services through oral agreement of the attorney, he was admitted at that time in California and suspended maybe sometime thereafter, right?
There's a question about that, Your Honor, and that is because the way that a respondent describes the engagement of his services, he says that he was initially hired to undertake getting Mr. Carter out of a record deal, and then subsequently that he became his all-purpose full-time lawyer. And because there's no record, we're at the pleading stage, it's unclear whether that occurred during the first major suspension that Mr. Sweeney was subject to, which was for a period of, I believe, 18 months. If you think about it, during the first 24 months of the representation, 19 of those months, Mr. Sweeney was suspended from the practice of law. All the while, practicing in New York under the auspices of being in New York, being advertised as a New York lawyer, showing on his email addresses that he's a New York lawyer.
Is where an attorney practices or where they're admitted, is that information that is generally accessible to the public?
Your Honor, given that this representation began in 2005, the record is absent when this information became available publicly. But the one thing that has to be pointed out, besides the court not recognizing the 3211 standards that should have been observed, that is to accept every allegation in the complaint as true, to give every reasonable inference in favor of the plaintiff, and to take every fact alleged and to fit it within some cognizable theory to sustain a claim, which the court didn't do. The court, on its own, decided to be the jury, the fact finder, by deciding, and he says it in his opinion, well, this information was readily ascertainable from, he doesn't even say when, but presumably from the beginning in 2005. Without a record, that's impossible to know. But the other aspect of what a court didn't do below was to contextualize the case. And the context is everything here, because we're talking about a celebrity who was a teenager from the South, uneducated, very little world experience, who was being advised by two other teenagers who had equal experience, none, who were dependent entirely on Mr. Sweeney, a sophisticated entertainment lawyer who'd been practicing in California and who knows where else, providing advice to what he claimed to be celebrities around the country.
Were any of it, oh, I'm sorry. No, go.
Somebody go.
All right. Clearly, this young man was taken advantage of at different points along the way by different people. Now, the question is, this particular lawsuit here involving this particular defendant, do the allegations fit elements of a cognizable claim? And so going back to a lawyer, the fact that a lawyer is practicing while his or her license is suspended can certainly carry some serious disciplinary consequences for that lawyer. But where are the damages, particularly with respect to your fraudulent inducement claim, where are the damages stemming from the fact that the lawyer was practicing without a license while the license was suspended?
What we allege in the complaint, Your Honor, is that he breached his professional code of ethics to Mr. Carter to communicate everything that was necessary to be communicated, to be responsive, to be trustworthy and honest. He was never honest about his status and his ability to practice law where he gave the appearance of being able to practice. But more importantly, before my time runs out for this part, California law applies here, and there is no dispute by any of the parties that it does. And I can go through that in my reply, but given the fact that California law applies, the Business and Profession Code in California requires a sign writing with certain disclosures. This was an oral contingent fee agreement. This case is absolutely controlled by the Depp decision, there were two of them, in California, which this court can review, as well as Mesa versus Lamorne. And what that means, and what the judge below got it partially right, because he did find that the contract had been voided. What he didn't do was go the next step. He just was desensitized to the issues because he didn't seem to think there was a problem with a out-of-state lawyer practicing in New York.
Were any of these claims time barred? I mean, because I anticipate that maybe your adversary will bring up any statute of limitations issues. Do you want to address that now?
I will, and particularly in view of, in connection with the Business and Professions Code, 6147. That's the one that requires a writing for a contingent fee agreement. Now, what the statute does and what the court fundamentally misapprehended was that statute means when the client voids the contract, there is no contract. So what happens is the client is entitled to disgorgement of all of his fees, hence why we asked for $20 million back. That's what we paid him over the 13 years.
Okay.
And what it allows the lawyer to do at that point, his sole remedy is to seek a reasonable fee. And how is that determined? Under the lodestar method. Reasonable rate, reasonable number of hours. The only remedy he has. But the court misapprehended that we have a private right of action to do so, and California precedent supports that conclusion.
Thank you. You'll get reply time.
May it please the court, John Harris for the respondent Sweeney. So let's be clear about the basics of this. Mr. Carter approached Ronald Sweeney in California sometime in 2004 or early 2005, and they reached an agreement whereby Mr. Sweeney agreed to represent Mr. Carter. That arrangement was not pursuant to a written agreement. Now, under California Code 6147, assuming that it applies to this, it says that a failure to comply with that section renders the agreement voidable, not void ab initio, but voidable at the option of the plaintiff, and the attorney shall thereupon be entitled to collect a reasonable fee. There is nothing in this statute that permits Mr. Carter to go back 13 years to the beginning of this relationship and say, you lied to me, you didn't tell me about 6147, that's a breach of fiduciary duty, that's fraud, that's malpractice. It is none of those. California could have made a private right of action under 6147, they didn't. California could have said that the remedy under 6147 is the disgorgement of all fees paid under the agreement. They didn't do that either. In fact, there is no remedy under this statute other than at the time that the agreement is voided, which happened, we agree, in September of 2018, at that moment, the amount that Mr. Sweeney was entitled to collect upon it being voided for the future, for services already rendered, had to be determined under a different standard. And that issue is before the trial court right now, along with Mr. Sweeney's counterclaims and Mr. Davis's defenses. The issue of the alleged unauthorized practice here, there is absolutely no claim that there is any connection between Mr. Sweeney's presence periodically in New York and any harm that was suffered by Mr. Carter in this case. Not a single allegation of that. In fact, they concede that there was no harm and that, that even if the statement that's alleged that he said while being retained in California that he had an office in New York, nothing that was said at that time was untrue. He was an experienced lawyer. He was admitted in California at that time. And the place where he happened to be present during the ensuing 13 years, assuming the truth of these allegations, is irrelevant to any issue that remains in this case. There are, in addition, 2 malpractice claims. Both of them are woefully deficient. The first deals with a default judgment that was taken against Mr. Carter by a law firm. That law firm wasn't paid in the first instance. The law firm sued. Mr. Sweeney is not alleged to have had any role in that. Mr. Sweeney is alleged to have reached a deal with that law firm to have a settlement agreement so that there was a certain amount of money that was due from Mr. Carter. That agreement, after some of the money was paid, it itself was breached. Again, no claim that it has anything to do with Mr. Carter or Mr. Sweeney. The bottom line is that the court, in rejecting a motion to vacate the default, specifically said there are no meritorious defenses here. And there are no meritorious defenses because you owed this money. There was an argument that the fees were excessive, but of course the fees were established by the settlement agreement. So there is absolutely no but-for causation there. On the issue about the California litigation firm, very briefly, there is no allegation in this complaint that anything happened here except that Mr. Sweeney failed to warn that the law firm might construe the contingency fee agreement in a particular way. This is an agreement that, after all, Mr. Carter read and signed. Another law firm presented it, and there is no claim for damage. There's not even a claim that there was a litigation that was brought based on that. So based on all of these factors, the court was well within its rights in dismissing these claims and leaving for future consideration the remaining question of what Mr. Sweeney is still due under the agreement.
Thank you.
I feel like I'm in the outer limits. We have absolutely no record, but just as the court did, it is deciding what the facts are based upon things that are said by the defendant, not by what's in the complaint and must be accepted as true.
Well, sir, how do you answer your friend's point that California Business and Professional Codes 6147 and 6148 provide a specified and enumerated remedy, and that's it? There is no remedy outside of the one that's specified by the statutes.
The courts of California have construed that statute to grant such a private right of action. We have cited the cases that do, and there are related statutes where, again, the private right isn't expressly stated, but is construed by the California courts as permitting it. Our complaint is modeled after the DEP complaint, which was granted the right to proceed after a summary adjudication motion was made and denied. But before I lose my time, we have timely alleged the malpractice claims, and the issues that he's raising are not factually correct. We are entitled to recover the costs that were expended in what he characterized as a meritless motion to vacate the default judgment. Yes, Mr. Carter owed the money, but Mr. Sweeney was the brains, the party who was responsible for participating in that litigation, and you'll see we have a reference in the brief where the court singles him out and said, Mr. Sweeney was aware of this lawsuit, and he should have known to timely respond to it. So the costs related to the failed vacator motion are certainly damages we suffered, and with respect to—
Was there a meritorious defense, though, on that vacator motion?
I don't know the underlying record of that claim, but I presume if Mr. Sweeney recommended that a motion to vacate be made, there must have been something, or else that was another instance of malpractice on his part. With respect to the California litigation engagement letter, he was advising appellant, Mr. Carter, when he went over that agreement with him. Because remember, if you recall from the briefs, there were several lawyers that were involved in the actions against the record companies for royalties that had not been paid. By the time they got to the California litigation firm, he had purportedly negotiated this very sweet deal for the contingency. And he told Mr. Carter there would be no payments in perpetuity. You get paid, the lawyers will get paid at the conclusion of the case. That was it. What I can tell you is post-filing of the complaint, we, on my firm, handled the dispute with that firm, and we were forced to pay an undisclosed amount of money because of that provision, which is a ripe and actual damage that we will be seeking against Mr. Sweeney, and will be it's a confidential settlement, so I can't reveal it in open court, but it is monetary.
Thank you.
Thank you very much.
Thank you. Eos Lavala versus A.O. Smith Water.
Good afternoon, Your Honors. Kevin McCaffrey for the appellant. Jenkins Brothers, as the court is aware, we're here on an appeal of a motion to dismiss, which was denied by the Supreme Court based on lack of personal jurisdiction.
Right.
I'll get right to it.
Right to the point. So the Supreme Court directed jurisdictional discovery and saying, what?
Exactly, correct. In terms of the jurisdictional discovery, as the court, I'm sure, is aware from the papers, here's the problem. The company has been defunct for 25 years, actually even further than that. Secondly, this is an asbestos
that doesn't
case,
mean,
which I'm sure—
Right, in terms of being defunct, that doesn't mean that, it's still something, right? I mean,
Sure.
it was alive at one point.
Exactly, it was. But here's the problem. In what's called NYCAL, New York County Asbestos Litigation, the company produced all records that it had, corporate records, advertisement materials, product literature, whatever you want to call it, years ago. There's no new, quote-unquote, discovery to be had. On top of that, the sole remaining witness from this company, David Bosford, was deposed over 4 days in connection with all matters, and the purpose was to get everything out in terms of the discovery that could be had in connection with asbestos litigation. The counsel for Vivala was there for all 4 days. Not only was counsel for Vivala there, they were in fact the main questioning counsel for all of day 1, all of day 2, all of day 3, and most of day 4. So everything was covered in this deposition as well, in addition to documentary evidence that was already provided. So at this point, we have already—
Are you trying to say that the Supreme Court should have just said there is personal jurisdiction or there isn't one, instead of setting off the I mean, that's what the sense I'm getting. This record you're saying that this record is it.
Exactly right, Your Honor. The record is what the record is. It's not going to change by quote-unquote additional discovery. There is no additional discovery. So what we have at this point is a case decided here where it was completely at odds with prior cases, decided on exactly similar facts. We have
what the judge did was he didn't say there is or is not discovery. He put it down for jurisdictional discovery.
Correct.
Do we owe that, since it is it was a discovery-related decision, if you will? You may know where I'm going with this. Normally we give discovery decisions of the Nisi Prius deference. So should we be doing that in this instance? Because it was jurisdictional discovery that was directed.
And again, that is a consideration. I'm sure the court could decide either way. But I would suggest this. What we have here is not even a fishing expedition. It's a faux fishing expedition, because in the year plus that this order was decided, there hasn't been any indication that Vivala's counsel has sought any discovery whatsoever from Jenkins. So the problem is the order, if you look at it, indicates that upon quote-unquote completion of discovery, at that point we can renew. The problem is discovery is never going to complete because they aren't even seeking discovery. So what we have is a case that we're stuck
Counsel,
in.
have they even since that decision, has the plaintiff served any additional document demands or additional deposition notices?
Absolutely not. I have not seen anything come across my desk, Your Honor.
Is there anyone else who could be deposed? I'm sorry, I spoke over you.
No, not at all, Your
It's a
Honor.
little difficult. Is there anyone else who could be deposed?
No, there's not. There's only one witness, and he's the witness who's existed for the last 10+ years. No one else has any contact with the company because it's been gone for a quarter of a century.
And are there other documents you think that exist that haven't been produced?
I would say this, Your Honor. If there were, all these very capable plaintiffs' firms would have located and discovered those documents in the last 25 years of litigation. Again, 25 years is actually a modest— I'm sorry.
Can you just address on this record your argument as to why there is not jurisdiction based on the discovery that has been established, and particularly specific jurisdiction as opposed to general jurisdiction?
Correct, yeah. Well, Your Honor, again, if you look at the facts of this case, what we have is a gentleman, Mr. Vivala, who worked exclusively with Jenkins Valves in the state of Connecticut. That's not disputed. Jenkins was headquartered in Connecticut for the entirety of its existence. Its administrative and customer support and also warehouses and distribution network entirely were located in Connecticut. On top of that, and most importantly, all products that were ever manufactured by the company were manufactured, sold, and sent out from Connecticut.
What about counsel, what about the marketing efforts that took place in New York and the pamphlets that says, hey, contact our marketing department, our sales department here in New York? Yeah. Is that, how should we view that? And even if we looked at that, would we still need some sort of causal nexus to the injury?
I believe that the case law would indicate that you have to have some sort of causal nexus. You'd have to have some sort of contact. Now, it needn't be so substantial that there's absolutely no doubt whatsoever. We're not saying that at all. But what I would say is that in terms of that office, which is the only thing that Vivala can possibly hang his hat on, if you look at the testimony, I think it's pretty obvious, especially reading between the lines, what you have is a couple executives who like the cachet of having a Manhattan office, and it even actually only lasted a few years, and then it moved back to Connecticut. Other than that, that's all we have. The testimony indicates that we have once or twice a week where Mr. Jack Spallin, who was one of the executives, would spend time there, and the chairman of the board was quote-unquote there from time to time. That's all we have. The only full-time employee was one sales representative. All sales were actually effectuated through the Connecticut offices from other locations throughout the country.
Thank you.
Thank you, Your Honors.
Good afternoon. Jason Weinstein for the respondents, Ralph and Mary Vavala. At the outset, this case is actually quite similar to another case recently decided by this court. In fact, Judge Oing and Judge Scorpula were on the panel for that. That was the Pira
Yeah,
case.
I'll have to tell you right away that I don't think this case is anything like that case. Let me ask you this. What does the plaintiff is a Connecticut resident, correct?
The exposure was in Connecticut.
Right.
That is
and
correct.
The valve was all the valves, the exposure, and the plate. So there's no jurisdiction based on, when I looked at your complaint, you pled jurisdiction here in New York based on the defendant's residence. So now we know that's not right. The defendant does not reside here for jurisdictional purposes, at least with respect to 3101, general jurisdiction.
Well,
so then we go to specific jurisdiction, and you say the plaintiff's a Connecticut resident. He was injured in Connecticut with valves that were manufactured in Connecticut, correct?
That's correct.
Okay, so where is the nexus?
Well, let me just take a step back because
No, I just want you to straight up and answer that question. What is the nexus?
The nexus is not the residence of the business. There's no contention that Jenkins
I don't mean to interrupt you, but I just want you to tell me. I don't want you to tell me what it's not. I want you to tell me what is the nexus.
The nexus is the business activities of Jenkins out of what itself called the home office in New York City, where Stuart Cattle, the vice president of sales, worked out of, the person who was overseeing all of the sales representatives. Now, just to be clear, a causal nexus...
Okay, how does that connect to the plaintiff's injury? Because literally that's Plavix and Bristol-Myers Squibb. So yes, okay, there was some marketing here in New York. How does that connect to the plaintiff's injury?
Beyond marketing, Judge, the direction of the sales were made out of New York through the vice president.
How does that connect to the plaintiff's injury? That's what I keep wanting. I've asked you this a couple of times. How does it connect? What's the connection?
The valves to which the plaintiff was exposed, those valves, the sale of those valves were overseen from New York. Jenkins took advantage of the New York market. The sales were overseen in New York. And therefore,
that was true of Plavix too, in Bristol-Myers Squibb, right? That's true. Plavix was sold in California. There was marketing in California, but like that case, the plaintiffs weren't injured in New York. They didn't use the product here in New York, and they're not claiming that there's no more than that. Is my problem, I guess.
Judge, I just want to make the distinction between marketing and sales, the direction of sales, and what may be discovered during the jurisdictional, because there's talk of there's nothing for plaintiffs to ascertain during jurisdictional discovery. The fact is that the deposition of the corporate representative, even though, yes, the plaintiff's firm and all of NICAL plaintiffs' firms were involved in that deposition, that was years earlier, and the purpose of that deposition was not for jurisdictional purposes. So although there was extensive questioning, there was not extensive questioning specifically pertaining to the direction of the sales out of the New York
counsel,
office.
all right, let me ask you that. Talking about the sales. The sales were sort of conducted in New York, correct? That's what
overseen by the vice president of sales, Mr. Cattle, in New York.
Let's say I buy that. But in terms of the actual products, they were all going to Connecticut, correct?
That's right.
And the manufacturing of the products are all in Connecticut, so they're taking the orders in New York, but everything's being transacted outside of the state of New York, though.
But under 302A1, that still relates to business done by Jenkins in New York. And in fact, What may be ascertained during the jurisdictional discovery is actually the finances of the sales. Did the money move through New York? That's an open
What's taking you
question.
so long? This case has been, it's like, as counsel pointed out, it's been over a year. Nothing's been done. I mean, if that's as simple as that, that was been one interrogatory, right?
Your Honor, I can't speak to that.
Okay, fair
I
enough.
can't deny that. But what I can say is that the appropriate remedy for the defendant, if there was an issue with the time delay, was to refile the motion,
Okay.
which Judge Silvera gave the defendant permission to do, refile the motion, and
Got it.
if there was an issue that the discovery wasn't undertaken, wasn't prosecuted by us, then take
Thank
that
you.
up with Judge Silvera
Okay.
rather than appeal.
Okay, thank you.
Very briefly, Your Honors. First of all, there's nothing in the record which indicates that the New York office was a quote-unquote home office. That's a fiction. I've never seen that anywhere in any aspect of the testimony, or for that matter, in the affidavit of the witness. Two, sales were not quote-unquote made out of New York. The record's clear that the sales were effectuated by sales personnel located throughout the country, and then they went directly to Connecticut, where the sales were finalized, and obviously the products were sent out from. Next, there is no quote-unquote,
So it's a conduit, it's essentially a conduit. It's a conduit, it's a pass-through. There's no real, we may have activities in New York, but it's a pass-through. We're passive in the sense that we take the order, we send it off to Connecticut, they fill the orders, and then they send it out to wherever it goes, right?
That's exactly right, Your Honor. That's exactly right. And the last thing, second last thing I'll say is that quote-unquote years earlier, and as if this discovery were somehow stale, this discovery and these depositions were only taken about 4 or 5 years ago, from what I can tell. Again, 908 pages of testimony by very competent, I presume, attorneys. I think they probably covered what they needed to. And lastly, in terms of appropriate remedy, I don't believe that we can refile, because at this point we haven't closed discovery, because we can't demonstrate to the judge at the trial level that anything has happened in the case.
Well, sir, is it your understanding that you can renew your motion under this current order? You can renew your motion upon the filing of the note of issue, or upon the representation that jurisdictional discovery is complete?
I think we have to make a representation that jurisdictional discovery has been completed. That's the way I read that order, Your Honor. And unfortunately, the case is nowhere being complete, and we're still in it.
Okay,
Over a year later.
thank you. Any other questions?
Thank you.
Thank you.
Thank you very much, Your Honors.
Levinson versus 77 Perry Realty. Thank you.
Good afternoon. May it please the court, Eric Sable for the appellants Janet Levinson and Louis Levinson, who appeal from the denial of the partial summary judgment motion and the request for leave to amend their complaint to add punitive damages.
We got what it is. You got to get right to your point.
So, Your Honors, this is a very simple breach of contract action. The appellants are shareholders in a cooperative
All right,
apartment.
so the question that we have is that your argument is that there was an agreement. There was a binding agreement for them to go do the renovations that they put forth before the board, correct?
Yes, that's correct, Your Honor.
And the board takes the opposing view. So let me ask you this question. I'm looking at a letter that the Levinson sent to the board on dated October 9, 2013. And it says right here, unless I'm reading this wrong, it says, we shall be obligated to make the payments provided for herein, whether or not an agreement is reached for the proprietary lease and sale of shares to us. And we acknowledge that nothing herein constitutes an agreement by the co-op to enter such transaction with us. So how do we have a binding agreement if they even say that in their letter?
So, Your Honor, that was an agreement that was drafted by the board council, and that was required for the appellants to sign before they were able to go forward.
And did they sign it?
They were required to sign it, or else they would not have been able to go forward with their previous.
And did they sign it?
Yes, they did sign it.
Okay, there you go. That's a simple question. They signed it, right? They didn't have to sign it. If you're saying that it was prepared by the board's attorneys, They could have rejected the letter and said, I'm not signing this letter.
That's correct, but if they did not sign the agreement, then they would not have been able to go forward with their alterations. The board was holding them hostage.
It's like the
with
chicken and
respect-
the egg situation, right? What comes first, right?
But,
Okay.
but even irrespective.
Counsel, if you're relying on the email exchanges to establish that there was some sort of binding agreement, those email exchanges, did they contain all essential parts necessary? Like, was there a date for closing? Was there financing? Were all the material terms there?
So our position is that yes, all of the material terms of the agreement were there, and there was a letter that was sent to the shareholders of the corporation that's part of the record, page 1222, where it's even the board addresses that point and says that the responsibility for maintaining, repairing, replacing the roof would be transferred to the purchasing shareholders. So there was no question of there was no question of the price of the shares or the responsibility for maintaining the roof space, and that was.
Then I guess my next question would be, the person who was involved in this email exchange, Mr. Kerrigan, did he have authority to bind the?
Yes, he was the assistant secretary and an officer of the board and did have the ability to bind the corporation to the terms of the agreement.
Okay.
And with respect to our claim to add punitive damages, this is a simple addition to the ad addendum clause to our third cause of action for the breach of the business corporation law, as with respect to the amendments that had been passed by the corporation. And this is not prejudicial to the respondents at all in this case. And the fact is that the conduct that the board continued to act with in treating the appellants differently from all the other shareholders of the building reaches a level of punitive damages, and we believe that this should have been included in the business corporation law, breach of business corporation law cause of action, and for a trier fact to determine if punitive damages if the appellants are entitled to punitive damages for this breach.
Okay. Anything else?
That's all I have. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. With regard to Your Honor's question about the October 8th letter, where the appellants expressly state that no agreement had been made, the appellants tried to explain that away by saying, well, we were compelled to sign that letter. But what they can't explain away is then again on November 21st, 2013, this is record page 1225, appellant states in an email to the managing agent, quote, since we do not have the roof rights, we will not be moving skylights or touching the roof membrane at all, but at least you have the letter on file approving this prep work if we are able to purchase the roof rights. There's no question, taking the course of conduct of the parties and all of the emails back and forth, there was no point on September 30th, 2013 that the negotiations ended. They continued about maintenance. There was going to be a meet and confer about when one party's maintenance and obligations and rights ended and the others began. And so that's that on that point. On the authority point, Your Honors, this statement by appellant's counsel that the managing agent was also an officer of the corporation appears to be made up out of whole cloth. It doesn't appear anywhere in the record, that's for sure. And
Did you dispute that at the lower court level?
I'm sorry, Your Honor?
Did you dispute that? Was that one of your arguments, that they didn't have the authority? Or was that something that the court addressed on its own?
Below, we did not brief that point, Your Honor. And so the court reached that determination. But upon receiving that order, what the appellants didn't do was move to renew and say, Your Honor, and trust me, we deal with appellant's counsel quite a bit, and they're very good. And if there was anything in the record, they would have brought it to the underlying court's attention and said, Your Honor, here is new evidence that would have altered the underlying determination. And they've had an opportunity on this appeal as well, 2 briefs, to point out, well, here's what we would have brought to the court's attention. Here is the proof that the managing agent had authority, the requisite written authority to bind the corporation.
Well, even if that was so, there's still, you have all these emails and these letters that kind of indicate that, okay, if he even had the authority, but there was no binding agreement that we even entered into, right? I mean, that's the bottom line, right? I mean,
Well, Your Honor, that's what we thought was the bottom line on the underlying motion, but the court's point is a good one as well. I mean, we have a managing agent, we have Court of Appeals case that says a managing agent cannot bind a corporation by way of a real property contract of sale unless there is express written authorization to do that. Here we have a completed record. There's a motion for summary judgment not to dismiss, and the appellants had 4 years of discovery to develop a record to demonstrate that this email sent by the managing agent bound the corporation. And here we are, the case is ready for trial upon resolution of this appeal, and there's nothing in the record that could provide a fact finder anything that they could have an inference that this writing existed.
Your time's running out. What's your response to the punitive damage claim that he believes that that the court should have allowed that amendment?
Yes, Your Honor. My response is twofold. One, the appellants knew of this potential amendment when they initiated the case. They knew of it when they amended their complaint the first time, and they waited until after discovery is closed, after they certified that the case was trial ready, and they still, to this day, have never justified that delay.
Well, what the ultimate touchstone, as we know, is prejudice. So in what manner were you hindered from defending the demand for punitive damages by virtue of the unexplained delay?
Well, Your Honor, to demonstrate punitive damages, there needs to be an objective, it has to evince outrage. It has to be egregious. We would have asked questions of the deponents, and we may have even called additional witnesses to discuss, did you find, other shareholders in the building to sort of dive into this outrage? And my other response is the idea that this run-of-the-mill dispute between a co-op board and shareholders about whether they can, make amendments, or I'm sorry, make alterations to their units, this does not rise to the level of egregiousness that punitive damages are reserved for. And if we go down this road, because trust me, we do a lot of co-op condo work, we're going to have punitive damages claims all over because these disputes are rampant. And so, I just don't think it's a punitive damages claim.
Thank you.
Thank you.
So first, to address the point about the communications that happened after September 13th, our position is that once that email was sent, that's a contract, and whether there was a paper document presented to the appellants afterwards is irrelevant because the terms of the agreement were there, and once the agreement has been submitted, once the email was sent and received by the appellant, that's a contract. So the correspondence that was circulated after that fact is not relevant to the point about whether there was a contract. And with respect to the authority argument, the court addressed that point on its own without anything in the record to address the authority point. So it was, there's no management agreement, which would be in the complete control of the co-op, and there was nothing else that in the record to address the authority point. And with respect to the prejudice, all we're seeking to do is to add punitive damages to the addendum clause of the third cause of action. We're not asking for
No, but counsel, your friend makes a very good point. Discovery is closed now. If you had known that there was a punitive damage claim, they would have taken a different tack in terms of protecting themselves and defending the punitive damage claim, correct? I mean, we're talking about outrageous conduct that's, morally, wrong and all that. I mean, high level of culpability when it comes to punitive damages, and the questions may have been different towards your client.
I think that the complaint speaks for itself with respect to the conduct, and the respondent knew exactly what was in our complaint, knew exactly what the allegations were. This case has been ongoing since 2015. I think that they would have known, and there would not have been additional witnesses called with respect to adding punitive damage claim, because they knew exactly what the facts were. The facts were not changing. We're not adding a plethora of new facts that would have changed anything.
No, I'm not saying that. Not a plethora of new facts, but in terms of defending against the punitive damage, the records before what the defendant has, and there's nothing there to challenge the notion of whether or not there was outrageous conduct that needs to be punished. How are we going to do that? You're going to get the witness on the stand, and where we're going to go with that, right? Of course they're going to testify that there was outrageous conduct, that there was like high degree of culpability and all that. And there's nothing to... You're fighting a ghost at that point.
They're entitled to call witnesses at trial to
Okay.
address that point as well.
Well, is yours ultimately a breach of contract cause of action?
It's actually a breach of the business corporation law in the sense that the shareholders are being treated differently from the other shareholders of the building, and the fact that these amendments that were passed apply only to them and can ever in perpetuity only apply to them because they're the only people in the building that own 3 apartments, the only ones who can ever own 3 apartments because of the amendments that have been passed. So it's actually a breach of the business corporation law.
Okay. Thank you.
Thank you.
People versus Garcia. You may proceed. Thank you.
Good afternoon, Your Honors. Good afternoon. May it please the court, Svetlana Kornfein for Appellant David Garcia. The modification court was presented with clear and convincing evidence that Mr. Garcia is a low-risk offender. Among these weighty risk-reducing factors are that at the time of the modification hearing in 2013, Mr. Garcia had been in the community for 9 years without any accusations, arrests, or convictions of a sex offense. This is consistent with the numerous statistical studies that show...
In those 9 years, had he ever failed to register as a sex offender? And if he did, how should we look at that?
Okay. He did not fail to register in those 9 years. In the board's letter, they write that there were 6 untimely registrations. There are no facts or explanations or details provided with that, and he was not charged with failure to register. So they were obviously excused or de minimis. So no, they don't have any predictive factor, especially since he didn't reoffend. And all of the predictive factors cited by the judge are predictive factors that immediately upon reentry, because that's when the reoffending occurs. And that's what these studies show as put before the court and in our brief. And then after the first few years, if the person doesn't reoffend, the likelihood after 5 years is very low. And after 10 years, it's almost negligible. And Mr. Garcia, after 9 years without any reoffending, was at a low risk. He completed SOCTP on parole at a time when it had the most value, when he was in the community. He developed a long-term relationship of 7 years with an intimate partner who was aware of the nature of his crime. He had no criminal convictions. Again, the judge considered 3 arrests, 2 of which were for marijuana. 2 of these 3 arrests were pled out to violations. The 3rd one was dismissed. Again, any predictive value they would have would be on reentry when he was just coming out into the community. But he was in the community for 9 years. So there is the predictive value, if any, after his being 9 years without reoffending is very, very low. And all we have to do is show by clear and convincing evidence that he's a low risk. So
Well, that's an admittedly high burden, right? Clear and convincing evidence?
Yes, it's a high burden, but there are no negative predictive factors. It's almost definitional. He's not reoffending. He was out in the community. He's not reoffending. That is the definition of low risk. So I think that outweighs everything.
Thank you. You have reply time.
Good afternoon, and may it please the court, Kathy Murata for the people. Defendant's petition for a downward modification was properly denied, and defendant should remain a level 2 sex offender. Defendant's actions have consistently shown that a downward modification is not warranted here. As to defendant's failure to timely...
Was this defendant's first time seeking a modification?
Yes, it is. Yeah, this modification proceeding was from 2013. As to defendant's failure to timely verify his address on 6 separate occasions, I believe there is great predictive value to his risk of reoffending. If defendant can't timely comply with his SOAR obligations as a level 2, I do not believe this court can trust him to comply with his obligations as a level 1 offender.
Well, how do you answer your friend's point that those failures to register weren't met with any follow-up action? They wasn't charged. There was nothing further to that. So perhaps, I believe she characterized it, they were viewed as simply de minimis missteps.
I don't think that's an accurate description. I think the whole point of SORA is to closely monitor these offenders, and if defendant is consistently flouting this SOAR obligation, it makes it harder to monitor him, and it increases his risk of reoffense. Furthermore, I believe that defendant has admitted in his brief that he was convicted of failure to verify in 2021, which shows that, although not part of this record, it shows that this pattern of failing to verify persists to this day.
How do you answer your friend's other point that he's been on supervision now, the SOAR supervision, for a number of years and hasn't reoffended? Isn't that the strongest evidence that he's no longer in need of the registration requirements?
Yes, defendant has lived in the community for 9 years without reoffending, but I believe that the studies that defendant cites may be true in general for sex offenders, but here there are other factors at play that distinguish defendant from these studies. One, the failure to verify. He has consistently shown no remorse for his actions, which is evident from his job application in 2013, which was a few months before the modification proceeding. He has yet to complete an alcohol and substance abuse treatment program, either in prison or on post-release supervision, which demonstrates his unwillingness to take this seriously. He was intoxicated during the commission of the offense, which played a big role in him committing this very serious offense, and him failing to take this seriously and participate in programs shows that he is not deserving of a downward modification.
Thank you.
If there are no further questions, we ask that you affirm. Thank you.
Thank you.
Respondent mentioned Mr. Garcia's 2021 conviction for attempted failure to register. Yes, that was his first one. But that has to be seen in the context that in 2021, he was in the community for 17 years, and that it was 21 years after the incident. He has not reoffended. I mean, this factor just, everything else is a predictive factor, but if he hasn't reoffended, then what is it predicting? It's not predicting anything because he simply hasn't reoffended. And even as of today, he hasn't reoffended. So we ask the court to reverse the denial of the modification and to adjudicate Mr. Garcia risk level 1 because he really does pose only a low risk of reoffending.
Thank you. Suarez versus Adis. We have an appeal and a cross appeal, so. Okay, go ahead, counsel.
May it please the court. Good afternoon, Your Honors. Jeff Beauchesne from the law firm of Pearson Salvato. I'll cut straight to the chase. The trial court erred when they granted the respondent's motion to set aside the jury verdicts and direct a new trial on damages in this case for the simple matter that they considered evidence that was not admissible. The court, in their decision, the trial court, did acknowledge that 6 juror affidavits indicating that they had misapprehended the jury verdict sheet.
Let's look at that because this is that's what happened here. From the record, I understand. You had 6 jurors, their affidavits saying, oh, we wanted the plaintiff to get $250,000. From what I gather, I'm reading it, they had discounted themselves how much they wanted $250,000, not even knowing that when they're doing their verdict sheet, and the verdict sheet was straight up, I mean, both sides approved of it, did a 60-40 split on it, right?
That's correct, Your
They
Honor.
put a 60-40 split, and then they put $250,000 down. So
That's correct, Your Honor.
so when they're saying that, oh, no, we already discounted it, we didn't know you were discounting it even further, that verdict sheet seems to belie that statement that they made, just by looking at it. Right?
That's absolutely correct, Your Honor. And certainly, the trial court decided that the verdict sheet on its face was something that created an issue. Now, this is not a novel case.
Well, let me ask you this, because it was raised by the plaintiffs here, is that there's a fundamental, not telling the jurors about the apportionment portion was a fundamental error, and that requires a new trial because other departments have viewed it as a fundamental error. What, is it a fundamental error?
I don't believe so, Your Honor. In this instance, there was every opportunity for counsel for both sides to raise an issue at the charge conference. There was opportunity for counsel to raise issue at the time that the jury rendered their verdict. There was an opportunity before the jury was discharged for counsel to raise issue. That issue was never raised, therefore it is not preserved on appeal, Your Honor. Essentially, what the trial court did is they were, I believe, Your Honor, influenced by the affidavits.
The affidavits were the bootstrap to the fundamental error. It wasn't as if the attorneys came back and say, Judge, I think you committed a fundamental error, with having no sort of leading down that road situation.
If we are to take the trial court's decision, Your Honor, we are to say that there is somehow a fundamental error that no one but the trial court has pointed out or identified. If you eliminate the issue of the 6 juror affidavits, which the trial court claims to have done in their decision, then there is no objection at any point throughout the entire...
How do you address the Best case that was cited by the trial court in its order and also by your friend in his brief?
Your Honor, I would direct the court more poignantly to Martinez. I think Martinez in this instance is most on point, which is a case decided by the First Department. The appellant cited no cases coming out of the First Department. In that Martinez case, there was actually a juror affidavit that was submitted by the appellant party that indicated that juror did not understand the jury charge and the standard of care in a medical malpractice action, Your Honor. The juror actually submitted a question to the court at the time of jury deliberations, and the court answered that question. The court on appeal, this court, Your Honor, deemed that answer was sufficient and that the affidavit was not something that should be considered. Therefore, the trial court's decision to overturn the defense verdict in the Martinez case was overturned by this court. So I think that is...
Best is like factually on all fours with our case, right? In Best, the Fourth Department said, we're not considering the affidavits. I believe they came out and said that. We're not looking at the affidavits. What we're looking at is the charge as it was given and the verdict sheet. And we noticed that the judge, and it was not preserved, I believe, in Best, as it was not preserved clearly here.
Correct.
The court failed to instruct the jury to disregard its apportionment of fault in calculating the amount of damages. And the Fourth Department characterized that omission in the charge as a fundamental error that they would consider notwithstanding it hadn't been preserved.
I think your colleague, Your Honor, has pointed out poignantly that, again, this is not a novel case. The verdict sheet itself lends itself to jurors understanding exactly what they were doing in that instance, that there was 60% fault levied against the plaintiff in this instance and 40% fault levied against the defendant. So with all due respect, I think the more poignant point is that the trial court, used the affidavits or used a fundamental error in order to, a means to an end, in order to
couldn't unsee them.
Correct, Your Honor. Thank you.
Thank you. So you got a cross appeal, so I'll give you your 5 minutes, and then.
I was going to ask you how you want me to handle it.
Yeah, You got 5, and then he'll get back up for 2, and then you'll get back up for 2.
That sounds good.
How's that?
Hopefully, I won't even need my 2, but thank you.
Okay, thank you.
Your Honors, may it please the Court. Your Honors, plaintiff in this case is not trying to impeach. We're not trying to impeach the jury's verdict. Okay, what we're trying to do is have the verdict reflect what the jury intended.
We understand that. We got the notion. But the verdict sheet, and I mentioned this, is that when the jurors got this verdict sheet, and let's just put aside, let's say that the affidavits never existed. The verdict sheet itself, if you look at the verdict sheet, you know, the plaintiffs, I said don't look at the affidavits, but they're saying that we wanted the plaintiff to get $250,000.
Correct.
But the verdict sheet itself has 60-40 down there. And they
correct.
said that they discounted even though they put
they did discount it.
Yeah, but they discounted when they should, let me rephrase, that when they put the $250,000 down that they awarded to the plaintiff, and
Correct.
they also put down the apportionment of 60-40.
Correct.
What was their understanding of that? Right?
Judge, the understanding is that when the judge gave the comparative negligence charge, and remember, I don't think you can look at this case as we've looked at cases before COVID, and I know you think that may sound crazy, but what we have here is a situation where we're sending things by emails, we're having this case with masks on, we're using cameras, and everything else is going on. Yeah. It's a mess. Yeah. It's one of the first cases after COVID that we tried. What happened was the judge charged comparative negligence. Right. The judge charged the first prong of comparative negligence, but not the second or the third. Yeah, but the first part talks about talks about percentages. The second part elaborates on that. The third part talks about don't discount.
Right, and so did anyone ask for that aspect of 2:36?
No.
Okay. And did anyone, after the judge read his charge, say, Judge, I noticed you missed this aspect that prevents or ameliorates against the possibility there'll be a double reduction for the
No, Your Honor, nobody has. Nobody did, and that's why we then go to the case law.
So, counsel, this is Judge Scarpula. So why is that not a straight-up waiver?
Well,
I mean,
because
why is that not a straight-up waiver like every other single failure to object to a charge and failure to object to the jury verdict sheet? And in fact, let me just ask you, I read in the brief that the plaintiff was the one who submitted the jury verdict sheet, correct?
Well, it was kind of, I will say yes and no because we did it together. Okay, for what it's worth. I mean, again, we were working in difficult times where we said we'd email it, nobody's handing in papers anymore. I mean, the whole thing was
but I was
complex.
doing that before COVID. I didn't think it was so difficult.
All right, all right, fine. But here's what it comes down to. I understand what your point is, but every department, including the first department on one case by the name of, I think it was Wingate, talks about being something so fundamental that you don't need to preserve it. And that's the case.
What is so fundamental about about a charge that you don't ask for, like any other charge, like for example, circumstantial evidence, or there are plenty of charges that might be considered fundamental charges, but if you don't ask them and you don't object to them and you hand in a verdict sheet and you sign your name to it that says good, and then after the charge is read and the judge asks you, do you have any objection to the charge as read, and you say no, that means you've waived, like a lot of other
Judge,
fundamental.
Not in a situation like this. And we have case after case, not in the first department, except I think Wingate follows it, but case after case.
Are you saying that we have a case in this department that says that the failure to charge?
No. Yes. Yes.
What's the name of it? Because I didn't see one.
No, it doesn't go specific to on fours or on all fours with this case, but it's the, let me just find it here, Judge. It's Wingate. This is a case that's analogous here, and counsel cited to it actually, a new trial to prevent a miscarriage of justice, because the verdict sheet said, they said they should have put the word gross.
No, that's a verdict sheet. That's a verdict sheet. We don't have the problem with the verdict sheet here.
Well, no, but Judge, then what we have is that we have a general verdict, not a verdict, a special verdict. If you don't give a charge on damages with respect to don't decrease the apportionment, you've changed from a special verdict to
so let me
against everything defendants arguing.
Okay, so this is, we're all trying to understand this, the argument here, and the charge conference that took place.
Correct.
Wasn't this talked about during the charge conference? Because I didn't see, I don't have the charge conference in the record here.
The judge says I'm charging comparative negligence.
There you go, okay.
Okay, and he charged comparative, but he didn't charge comparative negligence. And Judge, those cases support that this is so fundamental that it requires a new trial and damages. I actually think...
No, but when you heard that the judge only charged one part of it, did you object?
No, Judge, no.
Did you say anything to the judge that would have allowed the judge to correct that if you thought it was wrong?
No, Judge, but remember this. The judge gave the charge for comparative negligence.
Right.
Okay? I mean, you have three...
I mean, I know, but counsel, let me just... I'm sorry, I don't mean to speak over you. Go ahead.
No, and you have case law that says unpreserved errors relating specifically with respect to not providing apportionment, law providing apportionment, requires a new trial.
Okay.
But not in this county, and not in this division,
It's
correct?
inferred. It's inferred by the case Wingate.
No, I
Okay.
mean, sure, but not in this,
Okay, you'll get reply time. Counsel.
To just touch on that last point relative to the charge that was made, I believe in the case that I did reference earlier, Your Honor, Martinez, there was an issue specifically in that case where the court did not charge circumstantial evidence, and that was brought up in the appeal, and the court declined to recognize that as a fundamental issue in that case, Your Honor.
Well, presumably we ultimately, under CPLR 4404, the interest of justice aspect of that, we have the power, and we've done it before in other contexts, to review an unpreserved error. I'm not saying this particular type of error, but an unpreserved error. What is it about this particular error that takes it out of the class, if you will, of being a fundamental error?
I think you have to look at the ultimate result, Your Honor. This particular plaintiff he was awarded ultimately about $115,000. If you look in the record, counsel has made a request that there be editor in this case and that amount be increased. This was a gentleman who was injured at the time at 49 years old, had a significant hip procedure, then proceeded to paddleboard in Southampton and go running and kite surfing. I've never been kite surfing in my life. God willing,
Counsel,
I'll be able
may I interrupt you for a second? Except for the affidavits, is there anything on the face of the jury sheet or the charge that would indicate that this is a fundamental error?
Absolutely not, Your Honor. The record is entirely void of any issue other than the judge making a decision in the motion post-trial. There is not one scintilla of evidence in the record, Your Honor, that there was any issue, objection, or anything raised.
Counsel, and there was no note from the jury indicating any sort of confusion outside of these later affidavits. There was nothing in real time, right?
That's correct, Your Honor. It was only raised after counsel conferred with the jury, after they were discharged. And certainly we cast no aversion to counsel as to what the conversations were or weren't. But the precise reason that we have these checks is so there is not an unmitigated disaster of dealing with a jury after they've been discharged.
Thank you.
Thank you.
Your Honors, you're looking at this in a fishbowl, and what we have here is a situation where the judge at 3:45, when the jury asks a question on liability, says to the jury, if you don't have a verdict by 4:15, you're coming back tomorrow at 2 o'clock. Okay? The jury was never charged as to apportionment. They have a verdict sheet that says this, state the amount awarded. They stated the amount awarded. That's what they wanted the plaintiff to get. We walk out of the courtroom with defense counsel, the jurors run to us.
But I guess my question would be the same question to you. In that time frame, they didn't say, well, hey, we don't understand. Do we award 60-40? Are we confused about the apportionment? They didn't ask any questions. There were no notes.
Well, but Judge,
they sent a note on liability, but nothing else.
But they got a charge on apportionment. They got a charge on apportioning fault. They didn't get a charge on returning a verdict on damages. They didn't get a charge that way. So for us to, and for counsel to say, well, he does this and does that, and therefore he got the money, he didn't get what the jury intended. And I think, and I know you disagree.
Well, I think my question is, do we know that except for the post? If we take out the post verdict affidavits, there's no way we could know that, right?
Well, we do know that because if you look at the verdict sheet, which is we can go to right now, and somebody had reviewed the charge, we knew it definitively. No, but that's why there has to be a new trial and damages.
No, but does it say doesn't it say total compensation?
No, that's the problem, Your Honor. It says state the amount awarded. It doesn't say gross amount. It doesn't say what does it get net. That's the problem with the questioning on the verdict sheet. Yes, nobody objected to it, but Judge, if you accept everything counsel said, what it becomes is a general verdict on damages. So you know what? You can't have your cake and eat it too. You can't say it's not done right, but then this is what we want. You can't have it both ways. It's either
No. Isn't there an apportionment section? So it doesn't become a general verdict because the jury's asked to apportion.
no. Once it gets to damages, it's part of the verdict sheet,
No,
but it's a separate question.
No, but the verdict sheet is all together. You can't parse it out like that.
Judge,
it says how much is this and how much is that.
Judge,
it's a special verdict.
I'm being a little facetious in the sense of how you're saying it, but remember, they didn't get a charge on apportionment, so how would they know? And that is a fundamental, by law, except, and it is inferred in the Wingate case, and every other department says, you have to give it. Think about it, how would they know otherwise? We want fairness, we don't want miscarriages of justice. This is what they intended to do.
But here's my problem is if you hadn't spoken to those jurors, you would never be making this argument.
The argument making,
never.
Well, the argument making, maybe if we caught it, but the other argument would be making that the verdict is inadequate and tremendously inadequate, $250 for this gentleman who had 5 years.
Well, that's a totally different argument.
Well, we
right?
have that as part of our brief, Your Honors,
Yeah.
and that's something that I think is something to consider with respect to this matter,
Okay.
because $250 is wholly inadequate for this plaintiff.
Thank you.
Thank you
Okay,
very
thank
much,
you.
Your Honors.
What do we got? Let's see. Shakiva versus industrious staffing.
$92,797.
Uh-oh. Okay, you may proceed. Hold on a second. Hold just 1 second. Is there any way that we could get the mic pushed down further enough for her to hear? Because we're not going to, okay.
Maybe if we
Can we, Tommy, any way we can bend down the mic for her? Can we bend down the microphone for her? Because we're not going to have anything. Yeah, why don't we do that? Because otherwise, we're not going to have anything, this is not going to be on the record. Yeah, there we go. Thank you. Okay. There we go.
Thank you.
Thank
Can you hear me?
Yes, now we're good. Thank you.
Okay. Suba Sakthival, appearing as a pro se appellant in Sakthival versus Industrious. I just wanted to summarize, I guess, my brief. On November 18th of 2019, I was assaulted at the workplace, Industrious Staffing LLC, otherwise known as the defendant. I reported the assault immediately after to HR, outlining the violation of safety in the workplace. Defendants were aware of longstanding threats to safety prior to the assault, but chose to repeatedly put me in a dangerous environment. Following my complaint, I was let go from my position on November 21st, despite exceeding work performance expectations and obligations. I've been unable to work since that date. And I put forth arguments that defendants violated New York labor laws 215 and 740. And as per case citation Castman versus KPMG, New York labor law 215 requires 3 parts: engagement in a protected activity, which was me notifying my employer of the violation and imminent threat. The second part is a disadvantageous retaliatory action, which was the termination of my employment. Part 3, the proximity between the 2 events, which show a causal connection, and also that no other reason was provided for termination and all performance obligations were met. In terms of violation of New York labor law 740, Part 1, I had repeatedly notified management of the threatening behavior from the other employee and the imminent danger and ongoing safety violations.
Excuse me, ma'am, I'm sorry to stop you, but what specifically were the safety violations?
So there is repeated threatening behavior and aggression from a aggressive fellow employee previously, numerous times previous to the actual physical assault. And every time I reported it, it just fell on deaf ears. No action was taken. And I did also express my fear of said employee, but no action was taken. One of the supervisors actually went so far as to say there was no issue or action to be taken because there was no physical altercation.
May I ask you, was it just towards you that you were alleging that the other employee was aggressive? Or are you alleging that the other employee was aggressive to everyone? I'm sorry, to everyone else in the company?
It was general aggressive and explosive behavior.
Towards you?
Towards other employees as well as myself.
Okay.
So yeah, I apologize. I thought.
That's what I know, it's difficult.
So yeah, and even after such physical altercation, right, they didn't take any steps other than firing the whistleblower, right? Part 3, management's negligence is a gross deviation from any reasonable person's standard of safety in a workplace. The employer is responsible for ensuring safety in the workplace. And I was merely a placeholder in what is substantial and specific danger to public safety in the workplace. As I mentioned, the defendants were aware of the harmful conditions and failed to exercise any diligence or preventative action and deliberately ignored the safety concerns that I had brought up, engaging in egregious conduct. And to summarize, I'm requesting appropriate relief for damages for loss of my livelihood, ability to work, my wages, reputation, quality of life, and emotional distress. And lastly, I just want to address that the lower court had erred in dismissal of the case, and I had, in my argument, cited numerous cases as to why the case should not have been dismissed. And I don't know if I should go through that, but it is in my brief as well as my reply brief.
So if I understand you, ma'am, and please correct me if I'm wrong, that the safety violations were your employer's failure to prevent the threatening behavior, and then ultimately to prevent the type of assault that you suffered from or were involved with.
Yes.
Those are the two kind of big picture safety violations, or that your employer failed to prevent.
Yes.
Okay.
Thank you. Thank you. Thank you. Your time is up. Thank you.
Okay. Thank you.
Extended CHA acquisition versus Mahoney. Okay, counsel. Oh, hold on a second. Gotta fix that mic.
Sorry.
There you go.
May it please the court. David Wolmuth of Wolmuth Marendeutsch for the appellants. Today I will address three independent reasons why the motion court was required to dismiss respondent's complaint. Each concerns termination of the purchase agreement. First, respondents terminated the agreement in writing. That's R-945. Second, the agreement terminated when respondents repudiated the agreement. And third, appellants also had a termination of their own. I'd like to begin by focusing on respondents' written termination, an issue virtually ignored by the motion court. By terminating, respondent gave up its right to bring this lawsuit, including giving up any and all claims based on seller's pre-termination conduct.
Counsel, are you referring in terms of terminating the contract, the request to not close on the 29th?
No, Your Honor. On April 5th, after those events of the 29th transpired, buyer sent a written termination notice to recover its security deposit alleging breach of the agreement. That's in the record at 9:45, and it is that, though it may sound counterintuitive, that waives buyer's right to bring this suit. But I will explain why it is exactly the result required by controlling, squarely on point, Delaware authority. Here, Delaware governs the agreement, and appellants are the sellers. I would like the court to please focus on just two things. First, Section 12.2 of the agreement, titled Effect of Termination, which is at 161 and 162 of the record. I'd like to focus in on subsection C of that provision, which is at R162. Sub C states, upon termination, all obligations under the agreement shall terminate, and there shall be no liability among the parties thereafter. Second, I would like the court to please focus on the Delaware case I was mentioning. It's a chancery decision in Yatra Online. Yatra Online is cited repeatedly in our briefs, and I'll just mention it briefly.
Let me just make sure I'm clear. You're saying that the buyer's repudiation, their termination of the agreement happened on April 5th, no time before that?
No, it did happen before that as well, but this is the one that I think is
Well, it happened twice?
Yes, they terminated when they anticipatorily repudiated the agreement, which is what I think.
So now we're talking anticipatory repudiation? So then that would imply that there was some sort, if it was the 20, whatever date before the 5th, and then it happened again, was there some kind of negotiation going on in between?
Yes, what happened is there was an anticipatory repudiation of the agreement on March 26th by the buyer. The sellers had their own termination notice outstanding from even earlier.
Yeah, but that was resolved, though. That earlier termination notice was withdrawn.
Conditionally withdrawn on the closing occurring on March
29, correct. Okay.
So it accelerated when the closing did not occur. The reason I started...
So that's the third termination. You mentioned earlier on you had three terminations. One was the April 5th letter, the repudiation, the anticipatory repudiation on March 26th, and then the termination that you folks gave them, but you had it conditionally withdrawn based on the fact that it was going to close on March 29.
It's precisely right, Your Honor. And the reason I started with the April 5th written notice by buyer is that it's free of any factual quarreling or other confusion. It says what it says. And
Which termination or repudiation or did the lower court focus on?
None.
Oh.
It discussed briefly anticipatory repudiation, and as I will come to...
Well, it's, you know, throwing the word anticipatory really, for me, confused it because it was basically, I want to close on March 30th, and from my understanding of the record, you guys said, no, we're not doing that, and that you deemed that as a repudiation, and that was the end of it.
That, as to anticipatory repudiation, that is absolutely correct, and that is a key.
Well, it's not, I mean, it's no longer anticipated because you accepted it. You deemed it a repudiation. It was done, it was over.
Right, the contract from our perspective
Yeah,
was
it was
over
over.
at that point, absolutely, Your Honor.
When you throw the word anticipatory in there, it's kind of like, oh, you know, it's like there's some other stuff going on, and like, as my colleague said, there may be negotiations. Just call it what it is. We said it, you said you wanted March 30th, we said no, end of story.
It's in the record on the
Yeah,
26th.
got it.
They said clearly, keep your company. We're not closing then. We refuse. Our CEO called their counsel and said, do you know that means the deal is done? And they said, yeah, we understand we're not closing.
Were they not closing, or were they asking for a different date, and they were trying to negotiate a one-day adjournment for a specific purpose?
The buyer said that they were asking for a one-day adjournment because of a Jewish holiday, the second day of Passover. What the record reflects is our clients feared that that was not an innocent request for a one-day adjournment, but a setup, a slippery slope by which there would be a reopening of negotiations.
Well, did
So
your
they-
clients have any basis to draw that assumption?
Yes, 4 closing dates had canceled previously, 2 in March alone, on the March 1st and March 19th, and that's why our clients set the termination letter on March 22nd. But the point I wanted to make for Justice Pitt, the issue that confused the trial court is there was no time of the essence provision in the agreement, and therefore the trial court, the motion court, concluded that the March 29 outside date was not an essential term. But that is contrary to Delaware law. I would direct the court to the controlling authority cited in our brief, Dermatology Associate. Sellers were entitled to stand on their contract. When a firm outside date is established, not will try to close by then, but it says it's a drop-dead date. The law is abundantly clear in Delaware that the sellers were entitled to say, for any or no reason, all right, if you won't close on Monday, we are done. And that is exactly what they did. And what's interesting, in addition, the third termination.
Well, see, then that's why I'm confused. So then why are we even talking about an April 5th termination if you're saying that it absolutely happened on the 29th and it wasn't in a negotiation?
Because if this court did not accept that proposition of Delaware law, as the motion court did not, we would still prevail because of the April 5 letter. But the law is abundantly clear, and you're right, Your Honor, we should prevail for sure because of the absolute unequivocal termination on March 26, asking for a one-day adjournment. We feared more. Because we feared more, we accepted that. We changed our position in reliance based on accepting their termination. We canceled a crew that was flying in to rack the server, load data to deliver it to the buyer. We had to tell the employees who we had just told on Monday, you're going to work for somebody else. Guess what? On Monday, you're still working for us. We had to tell them that on Friday. It was delicate because those employees are needed to meet our obligations to the Department of Health. We deliver essential services, home health care for special aid
Got it.
patients.
Thank you. You got reply time. Thank you.
Thank you.
Good afternoon, Your Honor. Michael Tiffany from Leader, Burkine, Kaleo, and Silverstein, co-counsel for respondent in this action. I would just like briefly to introduce my co-counsel, John Zumo from Gutnicki LLP in Chicago, Illinois, and seek permission for him to make oral argument in this case. He was admitted pro hoc on September 16th, 2022.
Okay, so I'm compelled to make this comment, as all my veteran justices have made. We have so many thousands of lawyers in this state, and we had to go to Chicago. No offense to counsel from Chicago, welcome to New York, but really, motion granted.
Thank you, Your Honor.
Thank you, Your Honor. Okay,
Good afternoon. I'm going to quickly, this is John Zuma on behalf of respondent and what I'll term buyer in this case. I want to quickly address the seller points that were raised right now on buyer termination. And in that regard, I think Your Honor, or one of Your Honors, pointed out the fact that we've got a repudiation issue, which occurred before, roughly about March 26th, and then we've got the termination issue. With the reported repudiation issue, I mean, there's one email, and I just want to focus the court in particular, from Mr. Aquilari, who's the CEO of the seller, which occurred on the closing date, right? And this will tell you a little bit about what the effect of the buyer's purported termination or repudiation was on Friday the 26th. Their investment banker says the buyer is ready to close on the 29th. The CEO responds, while they do have until 5 p.m. today to wire closing proceeds, we do not expect that to happen because all the closing documents are not signed, there's no calculation of the amount of proceeds to wire in the absence of closing documents, and we have not delivered the server, and our CHA employees have been instructed that they will remain in our.
So I'm glad you made that point.
Yeah.
So when you point to that email about how they got to 5 o'clock, did anybody show up on March 29 before 5 o'clock from your side? Because in my understanding, you're going to close. You show up and the other side doesn't show up, you got to breach a contract claim. So if he's saying in that email, and I saw that email saying, well, I doubt they're going to make it at 5 o'clock because I don't have the financing, I don't have anything. Did your clients show up on March 29 at the closing office?
Right. There was no physical closing on that date, but
Did they get online then, virtually?
They begged. There's a plethora of
Forget the
communications.
begging. Did they get on virtually? We all know virtual. There are always taglines where you show that you're going to go into some sort of virtual office or virtual location, or there's a Teams call. Is that in the record?
None of that was set up. They completely stonewalled us. You can see it from their own text communications and their communications with each other. We could not contact them. They said, ignore.
So do you have
we hit
an
5
email?
p.m. and they said, phew.
No. So do you have an email when you say, whoosh, the finance guy, is the finance guy sort of like a disinterested person in the sense that he's not on the seller side or the buyer side?
No, he is the seller's investment banker, and our investment banker went around to him to try to get some access to the seller.
Right. Do you have that in the record that you're sending emails to the finance guy saying, where's the link to get on this call? Where's the virtual? We want to get into the virtual office.
That's all. Well, there was no virtual office, but that's all part of the record. All of the communication starting late Friday the 26th through the end of the day.
Saying that we're going to be there. We're going to be on the 29th, right?
We're saying we want to pay, and then they say, well, it's $58 million instead of.
Fine, okay, but in terms, so then what you're saying, then there's a factual issue here, right? It sounds like there's a factual issue, no?
Because the seller never disputed it. In fact, it's on the record that the buyer was ready, willing, and able to close.
Well, that's only if the seller didn't deem what you did on March 26th as a repudiation, right?
It wasn't, because they clearly knew it wasn't a repudiation, because under the case law, right, I don't think it's a repudiation in the first place, but even if it was, let's just say that email, right, was an absolute repudiation. Right. The sellers, in no way, shape, or form, their own testimony demonstrates that they did not rely on that. They didn't take it as a repudiation. They ran from this all weekend, then they asked for more money, and then they were, when it hit.
Well, but that also then that feeds into the inquiry that I would have that, those kind of facts then lend itself to support whether or not there's bad faith, whether or not they take the position that there was an absolute repudiation on your part and they deemed it a repudiation. So then all the other stuff that came in after the March 26th notice saying that we want to have the extra day, all those factual circumstances coming post that moment goes into, in my mind, feeding my questions about whether or not it was bad faith, whether or not there was a valid determination by the seller that there was a repudiation. I mean, that's all swirling around at that point, no?
Well, I would point you, and I don't have a lot of time here, Your Honor, but if you would look at the seller's reply brief and the testimony that they cite to in Vince Aquilari's deposition transcript for the support that there's some type of question of fact on this issue, it's striking. What he said. And it all comes from seller. None of the evidence that Judge Borak considered was from the buyer. It was all the seller's testimony. There's nothing to weigh.
So it's your position that this is not a factual issue that we should leave for a jury. This is something that the court could have decided on a legal issue, and we should also be able to do so, or What's your position on that?
Position is that this is a legal issue, that the judge, as Judge Borak noted, that he had all the evidence in front of him. There was nothing to weigh, right? The only thing that he could have weighed would
So,
be...
counsel, can I just interrupt you for a second? This is Judge Scarpullo. That Judge Borak didn't say anything about your email that says, okay, deal is done. We are not closing. Not cited, not discussed at all, correct?
No, if you
In
look
fact, you look at all your evidence, and the seller is showing us all their evidence. But if we put it together, there's no doubt that you said on that day, we will not close. And that the buyer said, you understand if we don't close, I have to unwind the deal, correct? I'm just asking you, is that a true statement?
No, and here's why, right? Because that's true.
Well, I read it in emails, so I'm not sure how it could not be true.
Well, one, Justice Borak did note that. It was brought up extensively at the oral argument. It's in the transcript, and I believe, I'm not sure he touched on it in the decision in order.
He didn't.
Not at all, not even one word about it.
But here's why it's not important, because the seller didn't want to close because they didn't have a Fourth Amendment for the $9 million rebasing payment. That's why they had decided before the 26th that they would not close.
That is your factual assertion, right? That is your factual assertion. That is not something that we accept on summary judgment. And they deny that, correct?
No, Vince Acolari, their CEO, testified repeatedly that the $9 million rebasing payment is not part of the MIPA. Their own counsel at oral argument said, no, it's not in there, Your Honor. It's nowhere. He said, without a Fourth Amendment, why would you need a Fourth Amendment if it's addressed in the agreement? You would.
Perhaps because the Third Amendment expired and the terms therewith were not complied with. So new deal.
The Third Amendment didn't
The
expire
Third Amendment was executed on March 25th and said, apparently, at your client's request, we'll extend the outer date to March 29th, and we will withdraw the seller's notice of termination on the condition that the closing occur on or before March 29th. So why are they not allowed to rely on that Third Amended agreement and the terms thereof?
Because the case law is clear, including the seller's own cases. And if you look in our brief, the Snell-Phelps case, you can't change the terms of the contract and say we will not close unless you agree to these other terms.
But, sir, I just read you
and then run
what
out
my
the clock and
synopsis
ignore.
is
Right.
of the Third Amendment agreement, which was we the sellers will withdraw our notice of termination, and we will extend the closing date to March 29th. And we would make the withdrawal of the termination notice on that condition. And then March 29th comes and goes with no closing.
Because the sellers refused to close. It's clear on the record, and it all comes from the seller's testimony. There's no closing without a Fourth Amendment, without the rebasing payment being covered. It's a deal breaker.
Counsel, what do you do with the counsel? Let me interrupt you for a second.
Yes, sure.
And ask you, what do you do with the testimony from defendants that the reason why we didn't close is because they repudiated? They told us they wouldn't close. What about that testimony? Does that not count?
Not if it comes in a conclusory affidavit in
Well,
support of
see,
summary judgment.
that is exactly my point, is that it's not just a one side. There's testimony going every which way here, including your own client's testimony and documents where your client said, we will not close. Not, let's try and continue negotiate. We will not close. And each time I ask you about that, you say, well, they didn't really mean it. I don't know what that means.
Well, and
here's what it means.
let's assume. Oh, no, I'm sorry. Answer her question.
Is that what it means is that almost immediately, the next day, there's texts and emails, attempted phone calls, and the seller knows it. That's why. Why would they ignore
wait a
us
second.
if they...
Let me ask you. Once you repudiate, are you allowed to just unrepudiate?
There's actually a case on it.
That's not a principle of law, right? Once you repudiate, it's over.
No.
You don't get to unrepudiate.
Under Delaware law, which is cited in our brief, I got to put on my reading glasses if I'm going to find it in the short time here.
We all do.
Is that there's a case on point, which is very clear. All the cases, by the way, that both parties cite.
You're citing West Willow Bay?
talk about, can I just let me get the,
Oh, yeah, I'm sorry, you're fighting two battles, yeah.
Oh, yeah. I just want to answer the question about what this case says, and then I'll find it, was that, no, it's not. Even, that's what our argument is. Even if our guys did repudiate, right? If you retract the repudiation and or the other party doesn't rely on it, or the sale or the transaction doesn't close for something other than the repudiation, it's not effective. And there's just reams of Delaware law.
Well, this is what
Okay, so what about the fact that they unwound the transaction, that they went and told their person not to do that? I mean, you're saying to us as a matter of law, we have to find that all this information means nothing, right?
No, all this information, if you look carefully at it, it all comes from the sellers. And can I circle back real quickly to the point between, when you've got sworn deposition testimony as detailed as Mr. Aquilari's was. And I mean, I don't have time to go into all of it, but it's unbelievable. I mean, down to the nitty gritty, right? Was the $9 million rebasing payment part of the calculation of the purchase price? Absolutely not. What was the Fourth Amendment for? It was to address.
You know what? We're getting far astray from whether or not there was a termination or repudiation. Justice Higgett, you have a question?
Oh, sorry.
Do any of these conclusions rest on inferences?
No, and that's the important part, right, about this case. And I think Justice Borak or Judge Borak noted that in his decision. This is an unusual case in the sense that it was all from one side. You look at this stuff, and I got to be honest, I was almost aghast or shocked at the deposition of some of the sellers' representatives that like most of this information was just being volunteered, right? That the Fourth Amendment was a necessity, that the $9 million wasn't part of the...
They volunteered it because they thought that they took the position that it was A, either repudiated or B, terminated, and that's as simple as that. So I think we've got all what we needed to know. Well, welcome from Chicago.
Can I just one thing before...
No, we got everything. Come on, thank you. This is a hot bench. This is where we go.
Your Honors, I'll try and move quickly. I know I only have 3 minutes. All of what we heard was after March 26th. We were ready to pay on the 29th, that we couldn't get a hold of them. None of that matters. The deal is done for 3 days already at that point because of the unequivocal repudiation on March 26th and the clear acceptance thereof by sellers. Second, Justice Lang asked very pointedly, did they show up? Did they try and do anything? They did not. And what's notable there is that sellers withdrew their termination notice of March 22nd on a single condition. Originally, the condition was there had to be a closing. But at buyer's insistence, we agreed that all they had to do was wire. So they didn't need to Zoom. They didn't need to show up. All they had to do was send the closing date cash payment set forth on the pre-closing statement.
And if the dispute of the money, about $58 million or whatever the money is, if there's a dispute, wire the money and settle that later on.
Correct, and that relates to Justice Higbett's question about inferences. There is no premium demanded here, even though the court was inflamed about it below, and for understandable reasons. We were standing on our contract right for the $9 million. They dispute that right. The record indicates in 2 spots that before they decided to sue here, they agreed that we would get that money as part of the settlement. And it never happened. It was going to be documented in the Fourth Amendment, but I direct you to the Shemia emails before that. Next, Mr. Ashlari absolutely did not testify that the $9 million was not covered by the agreement. It's in our brief, but the citation there is to the question that counsel asked Mr. Ashlari. He said not that the $9 million was not covered by the agreement, but that it would be handled in the Fourth Amendment, which is what it was contemplated. And later in his deposition, he makes very clear, if there's no Fourth Amendment, it's under the agreement, and it's our money under the working capital adjustment provision. Next, there was mention of Willow Bay. There is no ability to revoke or acquiesce to a new closing date, and Willow Bay is abundantly clear after there's acceptance and reliance.
You can't take it back.
You can't take it back. And that's another point where there is an inference against our client, the motion court inferred that the buyer was just exasperated with our refusal to grant the one-day adjournment. But the fair inference at summary judgment was that we were sick of these guys. There was context of repeated failures to close, and that was why there was relief. When the time passed, they thought it was a clean cut, a clean break once the outside date was passed. Unless the panel has questions, I have nothing further.
Thank you. Oh, well, last question. You didn't move for summary judgment, they did.
They moved for summary judgment. So, Your
And
Honor,
all the inference was drawn against you then?
correct. Every
Based on what you
inference
just-
was made against our client, which violated basic tenets of summary judgment law. And the thing, Your Honor, since you asked the question, Yatra makes very clear, this is not just a question of fact. They had a choice. They could either terminate or they could bring this action. The case must be dismissed based on documentary evidence because they elected to terminate. Yatra is binding authority, and it's abundantly clear. You can't do both. Election to terminate under Yatra is a distinct remedy.
Well,
It is desirable for parties because it cuts off their own liability on a no further liabilities clause like we have here.
okay, thank you.
Thank you.
Celentano versus City of New York. Okay,
Okay, good afternoon. May it please the court, Eva Jerome from the New York City Law Department on behalf of the municipal appellants. It was incumbent on ZHL as the movant to show that it did not launch an instrument of harm, but ZHL failed to meet its prima facie burden. ZHL offered no documents. and no
Counsel,
testimony.
correct me if I'm wrong. The record indicates that they were off the construction site for 4 months?
That's right. There was a
So
hiatus of workers for 4 months.
Yeah, so, I'm sorry.
A hiatus of workers.
All right, hiatus of workers, a hiatus of work in general, because they weren't there for 4 months, right? So the cinder block that the plaintiff tripped on, I mean, for 4 months, someone just, I mean, let's assume that it was the cinder block. For 4 months, you're telling me it's just laying there for 4 months and nothing happened? No one moved it?
The issue is is the burden of the movement to establish that they didn't launch the instrument of harm by they could have easily.
Let's assume that they satisfied their prima facie burden, that they didn't launch it. What are you going to bring forward to say there's a factual issue that, you know what, I'm not so sure about that?
There are many factual issues.
Give me one. All you need is one.
Well, there's a credibility issue because there's absolutely no documentation provided by ZHL about their cleaning schedule, in fact, what they left behind or what they didn't.
What's your cleaning schedule? I mean, I take that back. Okay.
I understand, but
It's late in the day. First time in the middle.
This court under Corprew denied summary judgment for a contractor who was also off-site for 4 months. So the mere absence of workers, when they admittedly had left material behind, although they said, oh, we don't know and we don't have any firsthand knowledge about what material we left behind.
But counsel, this is Judge Scarpula. Isn't there a lot of testimony that a week before the accident, there was no block in there? No one saw the block in there? That there was no indication that the block was in there?
The one witness, as I'm remembering from the city, said he didn't remember seeing it or not. I don't know if it was
He didn't see, no, not that he didn't remember. It was, he didn't see it there a week before the accident. And there is no doubt that this defendant wasn't on the site in the last week of the accident, correct?
Well, I believe my co-appellant believes that there is conflicting information about whether they were on the site, but
What evidence is there that they were actually on the site? I thought the city said they weren't.
no,
right?
and I'll just stick to my, to stay in my
Right.
lane.
So the city says they're not, and your witness says that there was no evidence that the thing that plaintiff fell on was at that place a week earlier. So where's the evidence? What is it?
But this again this is an issue of sort of inverting the burden where, as in Nestenberg in this court.
No, wait. So the defendant puts up an affidavit that says, I wasn't there, I didn't put it there, I have no idea how it got there. So the defendant meets their a prima facie burden by their own information that says, I didn't do this, I didn't put it there, I have no idea how it got there, I wasn't even on the premises. And then it's your obligation to raise an issue of fact, right? But instead, your client says, yeah, that's true, they weren't there for months and months and months. And B, we didn't see that cinder block a week before. So what evidence is there to raise an issue of fact?
But the problem is we never have to reach whether there is an issue of fact because they never met their prima facie burden. They did not submit an affidavit saying we did not put the cinder block there. They submitted nothing to that effect. Their principal, who was the principal of the company who said he had day-to-day operations, could not attest to whether or not there were cinder blocks that he left behind. They admitted they were the only contractor to use cinder blocks of all the 4 contractors. They had an obligation under their prima facie burden to have such an affidavit, which they absolutely failed to bring to support their motion for summary judgment. And the fact that there was no workers there for 4 months under corporu is a non-starter. And the idea that they were waiting for the punch list is also a non-starter because they could not have known at that time what would be required of them under the punch list, especially when the contract specifically said that the city could have them undo finished work.
Okay, thank you.
Thank you.
Thank you.
Good afternoon. My name is Lauren Donnelly, and I represent ZHL. We respectfully request that the order granting summary judgment to ZHL be affirmed. The evidence established that ZHL had been off the site for over 4 months before the alleged accident. This was confirmed by the ZHL testimony, Mr. Newsom's testimony, the city's witnesses, and the Levosky affidavit. They were not asked to return for any reason whatsoever to clean debris, to make any changes, or anything whatsoever.
Counsel, let me ask you this. Is the city's attorney says that you didn't produce any evidence or no one testified in your behalf that there was no block there, that there was no block there, or that you didn't put that block there. Is that correct?
No, that's not correct. The testimony is that we cleaned up the site after. Mr. Newsom confirmed that when we left the site in August of 2011, that there was no debris or any condition. The mere fact that it's a cinder block and my client used cinder block doesn't mean that it was our client's cinder block, but more importantly, it doesn't mean that my client put that cinder block in the mechanical room prior to the accident. Mr. Newsom testified that it wasn't there a week or so before. We were gone off the site. That's undisputed. Summary judgment was properly granted. And in this case also, ZHL is not a general contractor. They're the prime contractor for general construction. This is a WIX project, and all they were there to do was to erect the building. Finally, none of the Espinal exceptions are applicable here. We did not launch an instrument of harm. There is no detrimental reliance upon plaintiff's behalf, and we did not entirely displace the city's duty to maintain the premises. As a result, the cross claims for contribution and indemnification were properly dismissed, as were the contractual indemnification claim. In addition, one last point, and I'll be brief because it's late. The cinder block was an open and obvious condition, and it was not inherently dangerous. For all these reasons, and trying to be brief due to the lateness of the day, I will rest on my brief unless there's any other questions.
Thank you.
Your Honors, ZHL did not testify that it cleaned its site. He hedged, ZHL's principal hedged by saying, if ZHL is leaving a site, we would generally leave it in a clean condition. But that's not sufficient under several cases in this department, under Nestenberg, Steele, Melendez. And there's an issue of fact, Marrero, the plaintiff, testified that there was masonry debris strewn across the floor, and the only mason
I
was
hear what you're
ZHL.
saying, and I recognize what you're saying, but, I'm just having a little trouble getting over the fact that 4 months had elapsed between the time that the defendant left the project and the accident, and in those 4 months, you're telling me, or at least I have to accept that there's an issue of fact that the cinder block was sitting there for 4 months and nobody noticed it. It's just something that is kind of baffling, but look, it is what it is at this point, right? I mean, you're saying that, the cinder block was there.
There's also no testimony by ZHL that it properly secured any materials that it left behind. It admitted it left behind materials. So whether that's not establishing that they did not launch an instrument of harm by leaving behind or exacerbating what could be a dangerous condition. Excuse me. Again, the fact that 4 months there were no workers there is irrelevant on the question of whether ZHL met its burden. The absence under Corpru and under Hayes even when the city signed off on work in Corpru, that again did not mean that the contractor was entitled to summary
Did you
judgment.
challenge them, assuming that they met their prima facie burden on when you opposed their motion, did you challenge them on the fact that, and I'm sorry, I may have misread it or didn't see it, challenge them that they didn't provide a cleanup schedule or at least some sort of evidence that there's a cleanup schedule when they leave?
We did in our brief.
Did you oppose the motion by saying, hey, listen, there's a factual issue. We don't have from you your cleanup schedule from when you left the premise, when you left the project?
I don't remember, Your Honor.
Because that would have been great, because on reply, they would have been saying, oh, here it is, by the way.
But the witness during testimony said he didn't even remember whether there was a debris hauling company or not.
I understand that. I'm just saying that if you put that in your opposition papers, that would have been, I mean, this is where this whole argument is centered on, is that whether or not that cinder block was left there by the defendant, right? And so the question then becomes, and somewhere along the lines, I mixed up the burdens in terms of who does the cleanup. In your opposition papers, by the way, the factual issue is we don't have from them a cleanup schedule or what they do when they leave the premises or when they leave the project.
I
got it. Okay, thank you. Thank you very much.
Thank you very much.
Thanks, folks. People versus Ross. We made it to the end.
Allison Haupt on behalf of Mr. Ross. The search warrant was defective in this case. It was overbroad, it was unparticularized, it was without temporal limitation, and it was absent probable cause to believe that evidence of a crime was specifically going to be found on the cell phones that were searched.
The defendant was arrested and charged based upon the weight, and that he's charged with intent to sell based upon the weight, right?
Exactly. And so all that the allegations were that he possessed these drugs. And so absent anything, any case-specific
Possessed
facts,
with the intent to sell based upon the weight.
correct.
Okay.
But we need, in order to have probable cause to believe that evidence of that crime of intending to sell those drugs, that it could be found on their phone, there needs to be
What
facts.
evidence was recovered from the cell phone? Like, was there anything that
So we don't have I do not believe that the record includes a full list of everything that was recovered from this cell phone. A number of text messages were recovered that the people sought to introduce at trial. I believe there were 8 different text messages that they sought to introduce, but it could certainly have been more items that were recovered that just is not in the appellate record. But certainly those text messages were used or were intended to be used to link, to create that intent. The record's quite clear that the judge and defense counsel is having a discussion about how those text messages go to intent. It's why they're trying to suppress those text messages, and it's ultimately why Mr. Ross chose to enter into a plea, was because of those text messages.
So he didn't actually go to trial. He pled guilty, and where he waived his right to appeal?
So it's an invalid waiver of appeal, Your Honor. The court informed Mr. Ross that he was giving up any right to appeal. And so Green, Lang, Bassano, all cases that make quite clear that when you're told that there's an absolute bar to an appeal, that's an invalid waiver. And so this court is not prevented.
Was there any written waiver?
There was a written waiver, Your Honor, but that written waiver completely conflicted with what the court told him. And so again, case law says that when there's this complete discrepancy that's not clarified, then that invalid waiver is still invalid. And here, there's nothing on the record to suggest that counsel explained the differences in the written waiver versus what the court is telling him. And so if the court is telling him outright that you're giving up this right to appeal entirely, the case law establishes that the waiver is not valid. And so then, because of that, this invalid search warrant mandates reversal in this case. The only allegation is that he had a phone on him, had 2 phones on him, and there's nothing incriminating about possessing 2 phones. Many people possess 2 phones. There's, news articles talking about how people have phones for business, for pleasure, and so nothing about that establishes any sort of nexus between the crime and possessing the phone. And so what respondent tries to do, what the lower court seems to do, is rely on this conclusory assertion that people who sell drugs use their phones in order to do that. It's a wildly...
Inside the search warrant, was there any language that said that it was specific to looking for evidence of drug sales or particularity to drug activity, or was it just a search his cell phones?
So the warrant itself included a laundry list. It's a separate issue, separate and apart from the absence of probable cause, but that this was a general exploratory search. And so it allowed search of virtually anything that could be found on a cell phone, of names, text messages, addresses, and a catch-all, any data that could be held within the memory of a phone. And then within one of those buckets, those subsections, there's a reference to broad possession or sale of narcotics. But that has been found to be insufficient. I'd say to People versus Rosa, there's United States versus Walker, all of these are cited in our briefs, that these large, catch-all, get anything you can just with reference to a general crime is not meeting that requirement for particularity. But there are other issues well beyond that. There's no temporal limitation in this case, and this court's decision in People versus Thompson makes clear that that invalidates the warrant. The police were authorized to search for anything on the phone with no restriction on time at any point in time that Mr. Ross had been using that phone, with no relationship to the time at which he's accused to be possessing these drugs. And so cases cited by respondent make clear when there's no temporal limitation, that invalidates the warrant, and we have that issue here. If I can just go back, though, to the absence of probable cause, a conclusory statement that people who sell drugs use their phones is insufficient. In many of the cases that respondent cites, it's distinguishable because there's information, specific case-specific information that creates a nexus with the phones and the drug sales. So for example, Segovia-Landa is a case that the respondent cites. There are specific allegations that the phone was being used to engage in these drug sales. Barnett, another case, a case that specifically said with the absence of any temporal limitation, the search warrant is invalid. They also had specific allegations that the phones were being used for drug sales. That was included in the indictment. The undercover met with the co-defendant. The co-defendant called the defendant on the phone. The defendant came over to the location, and then they had a sale. So there, it makes clear that you need to have some fact-specific information that connects the crime with the phone. A broad conclusory statement that people who sell drugs use phones to communicate. People everywhere use phones to communicate. And I'd cite to People versus Booth for the point this is a case where they said in conclusory fashion that people who commit robberies use their phones to communicate with co-conspirators. They use their phones to arrange for the sale of the proceeds of those robberies. And the Second Department said, no, there needs to be something specific to this case to connect to the phone, that conclusory assertion is insufficient, just like it's insufficient here.
Thank you.
Thank you.
You may begin. Thank you.
May it please the court, Molly Morgan on behalf of respondent. I'd like to begin by noting that the valid appeal waiver does foreclose all defendants' claims here. The court here did not.
Let's turn to the issue of the search warrant, right? We'll leave that aside for a minute. So he's charged with possession with intent to sell, but there's no actual sale that's taken place. There are no other participants that we know of. It's just the phone and the weight. Why is that enough probable cause for the search warrant?
Yes, Your Honor. I would like to disagree with my adversary here. Cases like Segovia Landa and Estime do say that these allegations that drug traffickers use phones in these certain ways is enough. In fact, Estime said that specifically, like that those allegations don't have to be connected to any specific allegation that defendant used the phone to conduct drug sales. And even Segovia Landa itself, the court there, its reasoning was divorced from any particularized allegations as to defendant's use of the phone. That court simply said that the Second Circuit courts have routinely found that statements that drug traffickers use cell phones to communicate in the course of their narcotics distribution and store information are enough for probable cause.
I think that we could all agree that there was no temporal proximity inside this search warrant. Why isn't that alone fatal?
Yes, Your Honor, it's true that there's no temporal limitation here. Even assuming that defendant sufficiently preserved that issue, I think the nature of the crimes here are totally different from the Thompson case. In that case, the warrant affidavit itself specifically cited to one date that the defendant had sent the incriminating text message. Again, narcotics trafficking and distribution is totally different. I think by their very nature, they necessitate the use of these phones to coordinate these drug transactions. And it bears note that defendant had $800 worth of street level narcotics hidden on his person, and that's quite a large amount of drugs, and that would have required a lot of planning and communication to acquire those drugs and then distribute those drugs. The phones are just absolutely vital to conducting that kind of business. If I might just turn back to the appeal waiver, I would like to note that the court actually said that defendant was giving up his right to appeal, not any appeal, and this court has routinely found that colloquies such as the colloquy in this case, coupled with the detailed written waiver, which we also have, are enough to find that a defendant validly waived his right to appeal. Santiago, from a couple months ago, this court, there the court said that defendant's case would not be reviewed by a higher court and his conviction would be final. And there, this court also noted that any ambiguity was resolved by the written waiver. And again, the appeal waiver in this case covers the exact issues that defendant is seeking to challenge. There are also several other factors supporting the enforceability of the appeal waiver. And I would also just like to note, turning back to the warrant point, the warrants, it was just abundantly clear that there was probable cause that he had committed crimes and that evidence of those crimes would be found on the phones. Unless the panel has any questions, we ask that you affirm.
Thank you.
Your Honors, I want to point to Thompson because the distinction that respondent's trying to make just doesn't exist. It actually, in Thompson, the case was involving child abuse. And this court noted that that type of crime is one that actually does include the same sort of planning that respondent is talking about, that this was a family friend that he had built a relationship with, and that There's the general recognition that this variety of crime often entails repeated and habitual conduct, including repeated conduct on the internet. And yet, because there was the absence of any temporal proximity, that warrant was deemed ineffective. And so respondent is trying to create this distinction with drug crimes that's completely different than what this court already decided in Thompson, and yet they're exactly the same. It's these crimes that you're saying that there conceivably could be some habitual conduct, and yet because the only allegation here was 1 day, and you're not including any sort of temporal proximity, the warrant is overbroad. It's the same exact issue. And cases, again, cited by the respondent, Barnett is one of them, go through the analysis that Thompson set forth, applies it to the drug conspiracy case, and again says any lack of temporal proximity prevents the warrant from being valid. And so that invalidates respondent's argument. If I may also, just with the appeal waiver, saying you give up his right to appeal means any appeal. There's no distinction. I don't know how there could be anything different. If you're saying you're giving up your right to appeal, that's a complete bar to an appeal. And so Green and Lang and Bassano and all of those cases apply.
Counsel, under Thomas, in ascertaining whether there was a valid, knowing, intelligent waiver, the appeal waiver, do we look to the defendant's prior criminal contacts with the criminal justice system, including whether he took prior pleas?
That's one factor that can be considered, but taking prior pleas, we don't know anything about whether an appeal waiver had ever been included in those pleas. They're not included in all cases. We don't know whether he was allowed to take an appeal or did take an appeal in those cases. We don't know what his lawyers advised him of in that case. We definitely don't know what his lawyer advised him of in this case, because the record does not question whether his lawyer explained the waiver to him, explained the written waiver and the ways that it was different. And so that's one factor to consider, but we shouldn't assume that just because someone's been in the criminal justice system before that they have been informed of what an appeal waiver was. They're not applicable in every case. Not every jurisdiction requires an appeal waiver. And so that doesn't override a complete misinformation from the court.
Okay, thank you.
Thank you.
Yeah, that's it.